Hi, Scott. Can you let me know your last name and what case you're here for?
I'm here for the case of Scott Temple
Got
and
it.
the state of Maine. Yeah.
Okay, thank you. Hi, the person who just came on looks like it's Gary. Can you just let me know your name and what case you're here for? Well, you're muted right now. Can you unmute? Hold on, I'll see if I can ask you to unmute.
Okay.
There you go.
Okay,
you
my name is Gary Manuel.
Yep. Just so you know, Mr. Manuel, your case is on the agenda for the afternoon, so you don't have to be here until noon.
Well, they told me, they sent me an email saying it'll be 8:30 it'll start.
Right, so that email is one that we send every month, and it didn't say that there was an afternoon session too. If you look on our website, there's an updated agenda, and it shows, and I'm sorry for the miscommunication, it shows that your case is actually being heard starting, our afternoon session starts at noon.
Okay, so I will have to call back at noon.
You can stay on here the whole time if you want, but
Okay.
that's a long time.
Okay, well, maybe you can explain, because basically I have so much time to reiterate the main issues, or tell me, what do I have time to do and how much time I have?
So you have 10 minutes. And the things that you're allowed to speak about are if you think that there were mistakes of fact in the investigator's report, or mistakes of law, or evidence you shared that wasn't included in the report.
Okay. And great. Now can I do that now, or
Nope.
I have to do that at 12?
Yep. Sorry about that.
Okay, and then after that, oh wait a minute, who am I speaking with anyway?
Well, if you could see your screen, it would show you my name. My name's Amy Sneerson. I'm the executive director of the commission.
Oh, okay. You the one I'll be sending my, okay. Yeah, I see it at the bottom now.
Yep.
Okay, so those 3 issues, and have she made a decision on my case yet, or what?
No, the commissioners are going to do that at noon. And that's when you'll say what you want to say, and the other side will say what they want to say. And then the commissioners will vote right then.
Okay. Thank you so much, Amy. And I'll call back at 12.
All right.
Have a
Thanks
great
very
day.
much. Okay.
She's asking a question.
Hello, this is Kathleen Nealand. I'm in
Hi.
here for 8:45 meeting.
Yep. Okay. Thank you very much for letting me know. For
Okay,
now, I'm going to keep you on mute until it's time for your case to be heard. Okay.
so I don't have to put any numbers in yet or anything else?
No, you don't have to put any numbers in at all.
Really?
Yeah.
Okay.
Thank
I'll just have to do the unmute, right?
Exactly. Yep.
Okay, thank you.
Thanks.
Can you see me?
Nope. Can't see you. It could be that your video, you need to turn on your camera or something like that.
Start video.
There you go.
Okay,
There you are. All right. So I'm
Thank
going to
you.
keep you muted for now. Thank you.
yeah.
Hi, Commissioner O'Brien.
Yeah, okay, got it. Hi, Amy. Can I ask you a question?
Sure.
And I apologize if we've gone through this, but is when a case is settled, is the monetary amount public?
No,
Okay,
I mean, unless the parties choose, they can opt to, that's something that they usually discuss when they're settling it, is whether they
Right.
want to make the terms public or not.
okay,
We don't share that information unless they choose to.
okay. And that information includes not just the monetary, but what, okay, interesting.
Yeah.
Okay.
Yeah, that's an important part of our, the Maine Human Rights Act itself provides that settlement discussions and settlements are not public unless the parties choose to, or there's some lawsuit later on about the settlement.
Do you know? I mean,
In most of the cases, yes, I do, but
Okay.
yeah.
yeah, okay,
But we purposely, I mean, it could influence commissioners and how they think about
Right.
cases, so that we don't
Right.
share that information.
right, okay. Okay, interesting.
Yep.
Thanks. It's hard to believe I'm the first one on. That doesn't-
There's another Jeff on here, and I have a theory that it could be Jeff Ashby, but it might not be. It might be a different Jeff. I'm not
Okay.
sure. It might be Jeffrey Mace, so I'm not really sure.
Okay,
The Jeff who's on the meeting, could you just let me know your last name and the case you're here for? Unless you're Commissioner Ashby, in which case, let me know that.
It's Jeff Mace, M-A-C-E.
Okay, thank you. Thanks for letting me know.
Yep.
Morning.
Good morning. Good morning, Commissioner David, Commissioner Ashby, Commissioner Whitworth.
Is Melanie on? I seem to be having a trouble. Oh no, no,
Melody. Yeah.
it's okay. I got it now. There seemed to be something in the first case that it wasn't coming up as a PDF, but I think it's there now, so. No, when I click on it, it says this folder is empty. All the other cases open.
Which folder are you having problems with?
The cases to be heard. And
It's one in particular that's having.
Yeah, just the first one.
If you
McKellar
click out of the
versus-
folder and go back in, do you think it might just be big? I'll double check and see if it's up there.
I click on the second one and it opens. I got it. What's that? No.
Okay, I can't type quite fast enough to get there, but I'm glad it resolved itself. Thanks.
Hi, there's a few folks just joining now, and I'm trying to figure out what cases, what your names are and what cases you're here for. So I see Ms. Babin, I know the case you're here for. Actually, it may have been unclear, but your case is actually not being heard until noon. There's an afternoon session. And so you are welcome to stay on the meeting the whole morning, but you don't have to.
Okay. So I just
so
log back.
Sorry, I can't quite. I think you have two phones going right now. So I didn't get what you said. Nope, can't hear you. Now you're muted on something.
Do I just log back in around noon time?
Exactly. Yeah.
Okay, I can do that.
Thank you. Okay. And Aaron Sales, if you could just let me know the case you're here for, and Ashley, I think that's maybe who just was on the phone. I think that's the other Ashley.
Hi, good morning. My name's Erin Sales. I am with the law firm Baker and Hostetler. We represent Pyramid. My colleague, however, will be appearing on behalf of Pyramid.
Pyramid. I am not familiar with that company. Can you tell me a case on the agenda that you're involved in?
It's Pyramid Advisors, LLC.
Can you point, that's not a name that I immediately see on our agenda. Can you point me to a case on our agenda that you're involved with?
Ms. Nearson,
Yes.
it is for the Neeland matter.
Okay. Yes, okay, thank you very much.
No
Appreciate
problem.
that, Ms. Hardevel. Thank you, Ms. Sales.
You're welcome.
Yes, I think we're set.
Okay. All right. So good morning. I'm Deb Whitworth and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. The agenda is available online. You should have gotten a link to check the agenda. And the agenda includes the consent agenda. The consent agenda is a list of cases in which no written arguments were made to the commission in the allotted time period. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. So first we will get to our business section and adoption of the agenda and consent agenda. Is there a motion?
Move we adopt the agenda and the consent agenda.
Second.
And I think I will step in for Amy and say that commissioners, we will raise our hands as well as say yes, and Amy will call each of us in turn.
Thank you very much, Deb. This is the required protocol for remote proceedings. To adopt the agenda and consent agenda, if you say yes, you agree with the motion to do so. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And now to the minutes of September 20th, our last commission meeting. Is there a motion to approve or amend the minutes as submitted?
Move we approve the minutes as submitted.
Second.
So all those commissioners, each of you, if you say yes, you agree to adopt the minutes from the September 20th meeting. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And now to our director's report. Amy, take it away.
Good morning, everyone. Thank you for being here. So we didn't meet in October, so I'm reporting on 2 months worth of activity. So for you have for administration, a personnel report from me. You have a memo discussing the status of reasonable grounds cases. So covering September and October, there are 6 cases in active conciliation. 1 case was not successfully conciliated, so failed conciliation, and we had 2 successful conciliations. And the successful conciliations are agreements that I'm hoping you will vote to approve. You have memos from me on both of those. One is E190323, Small versus GOG Enterprises, and the other is E190424, Ho versus Charlie's Phillies Steakery. So I'm happy to answer questions about those, but I am hoping you will make a motion to adopt, to approve both of those.
So moved.
Second,
Okay, so the motion is to approve both conciliation agreements.
Yeah.
And if you say yes, you are in support of that motion. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
yes,
Commissioner Dusan,
yes,
Commissioner O'Brien.
Yes, yes.
I got to see your hand. Thank you. So that passes 5-0. Thank you. Next for investigation. In September and October, we received 75 new complaints. And for administrative dismissals, you don't have a detailed report about that because the function on our system that lets us report that doesn't work anymore. We don't have access to it. EEOC is changing its database, and that's the tool that we use. So I have gone through and counted them. We had in September and October 27 administrative dismissals. And for predetermination settlements, we had in September and October 36 predetermination, either withdrawals with benefits or settlements with benefits of about $755,000 to complainants. For quarterly reports, you have from me, hold on, you have from me a quarterly report on training and education showing that commission staffers either attended or delivered 12 trainings in the first quarter of the fiscal year. You also have a financial report from Melody. And you have a report that shows the pending inventory as of now. We currently have 689 cases pending. And that's what I have for administration, compliance, investigation, the regular director's report for new business. Oh, I'm sorry, litigation. Litigation, I would ask that we take after executive session. And for new business, I only have two things, both of which I shared with you. I think they made it into your OneDrive accounts. Legislative stuff is ramping up. And so we had two things. One is the only bill that our agency is submitting. There will be many other bills that we will be talking about, I'm sure. But the only bill that we are submitting is one we mentioned to you at the last meeting, I think, and relates to a relatively recent Maine Supreme Judicial Court decision related to the application of the Maine Whistleblowers Protection Act and unionized environments. So you have a very brief copy of the bill that we've submitted, and you have a significantly longer copy of the required State Government Evaluation Act report that we were required to file. It's just something that's required of all state agencies and entities at some point, and we have somehow managed to avoid it since 2009. So it's quite lengthy, and yep, you have copies. That's all I'll say about that. And that's all I have.
Okay, so we have 5 minutes until our morning session starts. So we'll see you all back here at 8:45 promptly.
Thank you. Before we start the hearing agenda for 8:45, Ms. Norwood, I just wanted to let you know that your case is actually set for hearing in the afternoon. There's an updated agenda on our website. So I'm sorry if the email was confusing and led you to believe that you needed to be here at 8:45. So the afternoon session will actually start at noon. So I'm sorry, and I appreciate you being here at 8:45, and I'm sorry for the inconvenience. Nope, I can't hear you. I think you're saying it's not a problem, but if you could unmute.
Is that better? Can you hear me?
Yes, thanks. Yeah.
Is it the same meeting ID and
Yes,
password?
yep, everything's the same.
Okay, and except it's gonna come at noon time.
Exactly.
Okay, I'll be there then.
Thank you very much.
All right, thank you.
Okay.
Okay, it is 8:45, so let's get our business or our morning session started. The cases on the agenda today, outside of the consent agenda, are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. As I said earlier, the commissioners have received and reviewed the investigators' reports and any written submissions submitted within the timeline. No new information or any written materials will be accepted today. Cases will be called in order on the agenda, except we are taking one case out of order this morning. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only number 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and I will ask that you introduce yourself as you're called to present your case. Thank you.
And one other thing for everyone is if you, we don't use the names of third parties in all of the reports that we've sent you. So please don't use the name of any witness. We've given them another pseudonym or descriptor in the report, so please use that. If you do accidentally use the name of a third party, I will likely interrupt you and remind you not to do so. Thanks.
So the case that we are taking out of order, our first case this morning is H210204, Jody Kation v. NFG Housing Partners, LP. Is there anybody here for the claimant?
I don't see.
I'm sorry, what's the case? What's the case again?
Yeah, Commissioner.
H210204, Jody Kation v. NFG Housing Partners.
Thank you.
It's the second to last case on the morning agenda. Okay.
Sorry for the confusion, commissioners. We spent the weekend trying to sort out whether we were going to take this case early or not. I don't see Ms. Kation here, and I don't know if anyone else here is here for her. There's a couple of folks whose names I don't recognize. Andrea Ouellette. I don't know who Barb is. Not Barb Archer Hirsch, but there's another Barb. So I assume if there's someone here for Jody Kation, this would be a good time to make yourself known. I presume that Ms. Kation is not present.
I
Okay.
move that we find then that there are reasonable grounds, I'm sorry, that there are no reasonable grounds to believe respondent discriminated against, complained on the basis of disability, or retaliated against her for engaging in MHRA protected activity, and that the complaint be dismissed in accordance with the act.
Second.
Hold on one sec. So commissioners, the motion, is my mic working? Can you hear me?
Yes.
Okay, so the motion is to find no reasonable grounds to believe that unlawful discrimination occurred. Hold on the basis of disability or retaliation for engaging in MHRA activity. If you vote yes, you agree with that. Commissioner Whitworth,
Yes.
Commissioner David.
Yes.
No, I'm sorry, Commissioner Ashby. I just skipped right over you, Commissioner
Doesn't
Ashby.
matter. Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Okay, thank you.
I thought it was a test as to whether we were listening. So.
I'm very impressed. You're ahead of me. So the findings are no reasonable grounds, and we will send parties and counsel a letter to that effect. And
Okay,
the parties, if you're here, are lawyers, you're welcome to stay on, but we're moving on to the next case.
so our next case, E190274, Mark McKellar v. The Hertz Corporation. This is a recommendation reasonable grounds case. Is there anybody here for the respondent?
Good morning to the commission. My name is Jennifer Whitney. I'm counsel from Seyfarth Shaw on behalf of Hertz Corporation.
So you have 10 minutes if you wish to use them.
On behalf of the Hertz Corporation, we have elected not to object to the investigator's report and recommendation and respectfully request that the matter be moved to vote and conciliation.
Thank you, Ms. Whitney. Is there anyone here on behalf of Mark McKellar? Anyone here from Mark McKellar's family or estate? Mr. McKellar passed away after we issued the report, and his family indicated they wish to proceed with the action. Seeing nothing. Commissioners.
Appropriate for a motion?
Yes, indeed.
Make a motion to take all three, that there are reasonable grounds on one to believe that there was unlawful discrimination and it should be conciliated, and that there are no reasonable grounds to believe that respondent discriminated on the basis of age. And number three, no reasonable grounds to believe that there was violation of MHRA requirements. Retaliation, yeah.
Second.
Okay, so the motion is to adopt all three recommended findings. So that would be reasonable grounds on the basis of disability, in terms and conditions and discharge, no reasonable grounds for discrimination based on age in terms and conditions of employment or discharge, and no reasonable grounds regarding retaliation. So if you vote yes, you agree with all three of those proposed findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
Thank you. So those proposed findings have been adopted, and the commission will send a letter to the parties and council reflecting that, and the hearing on that case is over.
Okay, our next case then, Amanda Sweden v. Career Systems Development Corporation, DBA Penobscot Jobs Corps. This is a reasonable grounds recommendation. Is there anybody here for the respondent?
Elizabeth Stouter for the respondent.
So good morning, Ms. Stouter. You have 10 minutes.
Thank you. The Job Center, the respondent, the Job Center, objects to the investigator's report and the recommendation that the commission find reasonable grounds to believe that discrimination occurred. The findings in this case were on sex discrimination for firing and also for hostile work environment and a retaliatory firing under the Whistleblowers Act. What I would say is that it appears from, we submitted a lot of paperwork to the commission, to the investigator during the investigation process. And I submitted some of the key documents from the center when I prepared my objection. This is a woman who was a security officer at one of the Job Corps facilities. This one is in Penobscot. And she made complaints at various times about a variety of issues, particularly about the treatment by one of her coworkers. The investigator found that trying to remember not to put names in, but that the center basically did not do enough. Their manager didn't do enough. There was no plan, there was no response to her objections. And I would submit that if you look at there was a huge amount of documentation and conferences, interviews with all of the different security officers and the managers involved. And each time an issue was brought up, there's ample evidence that it was addressed by the center. The first written information we have about a complaint is about 6 months after Ms. Sweden started working. There's evidence. She has said in her written submission that she continually complained about behavior to various people, including, this is kind of an odd situation where the supervisor isn't always the same. And it's unclear to me which supervisor is being referred to in the investigator's report, but she says she complained to her supervisors and then to her manager, did nothing. Manager reports this in June, which is about 6 months after she started, but it's clear that the managers already had conversations about previous issues. And if you look at the June 11 submission of the manager, it says, hey, I thought this was better now. I thought these comments were better and the situation had improved after I talked to your supervisors originally. She then makes calls immediately to the supervisor. She reports it to HR. HR proceeds to interview the other people on the team. There are several security officers at this facility. There are written statements and records and emails of those interviews. They proceed to have meetings with them. There's an incident that comes up in early July in which Ms. Sweden complains that this is what happened on the job, and I was talked to unfairly, and I was, basically there was not an altercation, but an argument that happened in the so-called gatehouse. Again, there's documentation that the center went and talked to all of the people involved. They looked at videotape, a written behavioral statement ends up being issued to this complainant. She complains about that and said that was retaliation. In fact, it was based on what the other people that were present at the time said, as well as what could be taken from the video. And that is the pattern that I see when I look at the written information and that I've tried to bring to your attention. Rather than ignoring these complaints or simply doing nothing or not enough, every time there was a complaint, there was an investigation by the managers or the HR department, and there's a fair amount of written documentation about that. Emails individually, documentation of written meetings. This all ends when Ms. Sweden's employment ended in October, actually on October 24th, and she had gotten several write-ups before that for various things, including attendance. She continued to complain, and it appears to me that when the complaints she made were addressed. The last incident happens on October 23. There is during the evening shift, there are a bunch of written communications started by Ms. Sweden to the acting manager of that day or the supervisor that day saying, hey, I'll help you by filling out the nightly log. And then she makes it sound like she was directed to do it. There's a fair amount of back and forth. The acting supervisor says, fine, thanks for the help. But she doesn't realize nobody's told her to do that. The center seemed fairly clear that Ms. Sweden was misrepresenting that she was told to do something she wasn't. The managers get involved that night. Somebody goes down to talk to them, says, look, this is not what's supposed to happen. This is what's supposed to happen. Everybody's supposed to report to somebody else. In the meantime, Ms. Sweden's log is getting erased. She was upset about that. She appears for her shift the next day, sees her log has been erased, even though she was told that she was not the one supposed to be putting together the log, and she walks off the job after an hour. And at that point, the center said, this is enough. The general feeling of the center was that they were doing what they could to address the problems that Ms. Sweden brought up. When they talked to the other folks that knew something about it, they were told that what they either saw, witnessed, or heard was different than what Ms. Sweden said or did. The center didn't feel like Ms. Sweden herself was taking enough responsibility for her own actions in all of this. And so these actions, the discipline resulting in termination of Ms. Sweden was based on her own actions, not because she complained about other people. And the entire course of these complaints shows that the center was acting and reacting and also acting and continuously saying, look, there has to be respect here, and also hearing that the problems were over at various times they addressed them. Sorry, I said that really fast, but I wanted to keep it short, and I was hoping I could save a few minutes here for rebuttal.
You did indeed. You have a little over 3 minutes left. But before we go to complainant, I'm going to see if commissioners have any questions for you. Commissioner Whitworth, questions for Ms. Stouter?
No questions, thank you.
Commissioner Ashby?
Yes, I have just a couple. I see the sort of he said, or I guess she said, they said aspect of some of these allegations of complainant. I understand that the respondents' employees in many of these instances just deny that things complainant claims they said they didn't say. Things like, if you, I'm paraphrasing, but if you report this as a sexual harassment claim, I need to, send it to the managers. This fellow who is engaging in these behaviors, that's just how he is. Is it the respondent's position that just there's a blanket denial of some of those more sort of sensational statements alleged by the complainant?
It's hard to say there's a blanket denial. What we did was try to look at each of those statements and figure out who they were attributed to and discuss them with those people. I don't think anybody has said, look, we just said that's how he is, just deal with it. I have not seen anybody that supports that was said.
Yeah, and I'm just being a little inarticulate, and I apologize for that. What I'm getting at is it does seem that it's known to the employer, to the respondent in this case, that you have a problem employee. At least it seems from the totality of the record in the investigation that the respondent has an employee who is, in fact, sort of widely known or understood to be a person who makes inappropriate comments of a sexual nature. Am I right about that? I mean, can we at least presume that that's the case, that the respondent does have this knowledge of this employee for really a fairly extended period of time, is engaging in these behaviors?
No, because I think this all starts. Oh, sorry. I think this all starts from a conversation that Ms. Sweden said she had with the HR manager when she first started, that, oh, there's one guy that could make comments and you should ignore them or bring it to my attention. That doesn't sound like the kind of thing an HR person would say. And what the HR person said was, I didn't say that. If we had that problem, we would deal with it then. Okay. So, and then as time goes on, there are mentions at different times that, the alleged bad actor said, yeah, I did discuss wife, some sexual stuff, but I stopped that. As soon as I found out it was bothering somebody, I stopped that. And and I think this is in early July when Ms. Sweden was interviewed, she said, yep, that was a problem at first, but that's stopped now. So I don't think it's correct to say we think we've got this bad actor here. We were there are a lot of references in these materials. So we're trying to be part of a team. They saw there was some friction in different places, but we were trying to work together. And sorry, I'll stop. So I think what I'm saying is, that's not how we see it.
Okay, great, thank you.
Commissioner David, questions for Ms. Stouter?
No, thank you.
Commissioner Dusan?
I don't have any questions.
Commissioner O'Brien?
No, thanks.
Okay, so Ms. Stouter, you'll have 3 minutes and 20 seconds when we come back around to you. So then there's Mr. Black here for Ms. Sweden. Is that correct?
Yes.
Okay, go ahead.
Thank you, members of the commission. My name is Eric Black, and I'm representing the claimant Amanda Sweden in this matter. Our position is that I think the investigator wrote a very thorough report, and that the commission should affirm the investigator's decision and find for the claimant on all three of the grounds that were discussed in the report. Ms. Sweden was the only female security officer at this particular branch of career systems. And from the very first day, she was warned that a particular individual might say things that, you're going to work with somebody that might say some things that might offend you. The commission can infer from that this person has said offensive things in the past and that the company knew about it before Ms. Sweden's first day on the job. That individual clearly had a prior history of doing things like this. In fact, she was told, "I'm confident that it will likely happen." Career Systems denies this, but that would be a pretty strange and specific thing to make up. And I have to respectfully disagree with opposing counsel in the sense that there might be some people in HR that might flag that as an issue for somebody coming in because they may want to know about it if the person says something. But this individual, the same one she was warned about, pretty much immediately started saying wildly inappropriate things, talking about seducing their wife, what kind of lingerie the wife wore, intimate details of sexual encounters. This person continued making comments about my client's body. I'm not going to repeat them just for decorum purposes, but they're in the report. Some of it's pretty lurid, matter. And she reported it, and the first reaction was that her direct supervisor just simply laughed. This person referred to all women by the B word, mentioned that all women were sexually promiscuous. And this is important because sometimes in this profession, they deal with women who have been physically or sexually assaulted. And this harasser was of the opinion that these girls were lying and trying to ruin a man's life. She continued to report this, and this continued over weeks and months. And as I think as one of the commissioners has mentioned, the reaction, as is mentioned in the report, was, well, that's just how this person is. And so up the chain to the security manager, was initially cited as a mutual disagreement between the two, like a personality conflict, when in reality it was much more than that. She was told that you guys need to learn how to get along. At one point, this individual actually yelled at her, saying, "I don't even want to hear you say his name anymore." She then sent an email that specifically mentioned sexual harassment, and that resulted in a meeting with the head of HR. But unfortunately, that, as is discussed further in the report, the head of HR essentially kind of avoided the subject a little bit, didn't directly, address those concerns, at least in that initial meeting. Now, of course, there was some, as opposing counsel had mentioned, there's obviously was at some point lots of emails going around. These things were put in writing, but I think even Career System admits that there were plenty of conversations verbally before things started to get reduced to writing. And meanwhile, some of this still continued. The harasser continued to talk about Ms. Sweden's body parts outside of her presence. She'd hear from other people. And then at one point in late September, the harasser was given a supervisory role over Ms. Sweden. And Ms. Sweden complained that was extremely inappropriate. And the response was, well, he hasn't bothered you lately. This bothered her immensely. She had a panic attack. She actually had to go to the hospital. So she filed a complaint with the commission. And immediately there were some changes. The manager who put the harasser in a supervisory role was I believe, removed from their position. The harasser was then sort of put back down to where he was no longer in a supervisory role. He was very upset about it. He began slamming things around the office, sort of engaging in outbursts. Sometimes she'd ask for assistance and he would ignore those requests. And then, what do you know, a few weeks later, Ms. Sweden was terminated. And as the investigator noted, the reasons for the termination have changed. In the actual employee behavior modification agreement, the document that discusses the reason for termination that was signed on the date of the termination, it talks about that Ms. Sweden made false statements. And then later on, it sort of shifted into that she left early, without permission, and that there had sort of been this long line of previous discipline, which I don't think really shows up in the record as much as has been argued. And so, but some of those reasons did not make it onto this form. This just says that her statements were false. It doesn't say that she left early without permission or that she had a history of leaving, of absences or any problems like that. So we would submit, there's been shifting explanations here rather significantly. And essentially, so the two big knocks against career systems on the termination would be, number one, her termination occurred just a few weeks after the MHRC complaint, which would be quite a coincidence. And second is that there's actually been shifting and different reasons for her explanation that have been proffered at different times. With that, I don't think I have anything further. Obviously, we believe that the sexual harassment here was quite extensive, severe, and pervasive. And again, I can go into detail, but it's all in the report. And the termination is highly suspicious. With that, I'll reserve the balance of my time and be happy to answer the commissioner's questions. I will note that I am somewhat new to the case. I just entered my appearance this morning. I'm taking over for another lawyer in my office. So if there are certain factual questions, I'll do the best I can to answer them, but I may not have precise answers. But I'll do the best I can. Thank you.
I saw that I was muted myself. Sorry about that. Thank you, Mr. Black. Questions for Mr. Black? Commissioner Whitworth.
No questions. Thank you.
Commissioner Ashby?
I don't think so. Thank you.
Commissioner David?
No.
Commissioner Doosan?
No.
Commissioner O'Brien?
No.
Okay. You have about 3.5 minutes when we come back to you, Mr. Black. Ms. Stouter, you have 3 minutes and 20 seconds left. If you choose to use them, you don't have to.
Just quickly addressing the last point first, I don't think that the grounds for termination have shifted. The BMA lays out the problems the night before about the same ones I talked about earlier about the misrepresentation of her authority. The previous problems with absenteeism had been laid out in previous documents. So Ms. Sweden knew that was a problem. The emails show that she knew that it was a problem that she left early. And that was certainly told, that reason was addressed with her, was given to her on the day of her termination by, that's both of the people that were present have said that. Other than that, the only things I guess I would mention are that Ms. Sweden was the only line security officer that was a female, but there were several other females involved in different parts of the center, including her manager, the center director. I think the deputy director at the time was a female as well. And it was also when these issues were raised and they were addressed, I don't want to make it sound like there were these sort of long email chains and between what Attorney Black and I said may have made you think that. It was more, these emails are just, the way we all communicate now. When people were asked what happened on a particular night or what was going on between so-and-so and so-and-so, that's how they kind of made their statements. They communicated what they saw. And from those statements, the other people present often disagreed with what Ms. Sweden said happened. In addition, as the complaints came out in the beginning, they were what the center learned was that Ms. Sweden was also a participant in many of these conversations. And I think that's all I have.
Thank you. Any follow-up questions for Ms. Stouter? Commissioner Whitworth?
No questions.
Commissioner Ashby?
None, thank you.
Commissioner David?
No.
Commissioner Dusan?
No, thank you.
Commissioner O'Brien?
No, thanks.
Okay, thank you, Ms. Stouter. Mr. Black, you have 3.5 minutes left.
Thank you. I'll be very brief. Just a couple very quick points to the extent that it's been inferred that Ms. Sweden was somehow a willing participant in sexual harassment banter. We would adamantly and strongly deny that. The other thing that I think is important here, just as a side issue, is that it may be that people in higher positions in career systems management, may have been female, but she was the only female guard in the group, where everyone else was male. And that is important to keep in mind, I think, and for discussions of the sexual nature that occurred frequently, apparently, during her employment. The other thing is just in terms of the shifting explanations. Look, the investigator has this document. This is the employee behavior modification agreement, and it's signed on the date of her termination. It talks that she made false statements, and that's the reason that's cited. It's there's no discussion of anything else here. Some of those arguments came on later, but on the day of her termination, there were there was a rationale given, and that was the rationale that she made a false statement. And the other things came along later on. So we would actually, again, say that these are shifting explanations and reasons for termination. Thank you.
Thank you. Follow-up questions for Mr. Black, Commissioner Whitworth?
No questions. Thank you.
Commissioner Ashby?
Thank you.
Commissioner David?
No.
Commissioner Dusan?
I have no questions, thank you.
Commissioner O'Brien? Okay, thank you, Mr. Black. Now we turn to the investigator, Alice Neal.
Good morning, commissioners. I'm Alice Neal, as investigator on this case. I've heard what the parties have had to say this morning, and nothing that it doesn't change my opinion of the case or my recommendations. I believe that my report lays out my thoughts and arguments on the case, so I don't really have anything to add from what you've heard from the attorneys so far today, but I'm happy to answer any questions that you have.
Questions for Alice. Commissioner Whitworth?
I do have one quick question. Alice, as I remember reading in your report, which was very complete, thank you so much. You said that, or you reported that the respondent said that she hadn't made a report for 6 months, and that when she finally did make a report, they took prompt action. Can you address that, please?
Sure. I do believe the complainant was making routine reports to her immediate supervisors, who brushed it off. And then when that wasn't getting somewhere with the CDOs, which is what their title is for that day, then she went to her manager. And this is where you heard Attorney Black saying that the manager just essentially saw it as a personality conflict, but that then once complainant put in writing in an email that she felt that there was sexual harassment, the manager knew that that would have to be reported to HR. And so then when HR became involved in early summer, HR did go through and investigate and do what it thought was an investigation. But that doesn't, to me, the steps that HR took from that point forward do not ameliorate or negate the lack of action for that preceding time since complainant started. Complainant was clear that she'd been experiencing sexual harassment routinely to her immediate supervisors, to her manager, and they weren't doing anything. So I don't think that HR can hide behind the fact that once they took action, that it was prompt. That's what I was trying to say with that. Does that help?
Yes, thank you.
Okay.
Commissioner Whitworth, any other questions for Alice?
That's it. Thank you, Alice.
Okay. Commissioner Ashby, questions for Alice?
Yes, and I think, Alice, am I correct to understand that even after taking action on the complaints, the manager still permitted supervision of the complainant by the coworker, correct? And that was a whole second
correct.
sort of set of challenges.
That is correct.
All right, thank you very much.
Commissioner David?
So, Alice, we're hearing about a lot of so-called actions in terms of these investigations and responses. Is there any evidence of discipline of the bad actor?
Not to my knowledge.
You said no?
Not to my knowledge, no.
Okay, yeah, I didn't see any in the report, and it strikes me as significant.
Commissioner O'Brien, any questions for Alice?
Yes, a real basic one. I'm trying to get a grasp of what the respondent really is. I see it's a youth, residential, a job development. Is it voluntary? Is it co-ed? And can you just give me a sense of exactly what it is?
What I know of respondent's facility is that I don't know if I believe it must be voluntary, and I don't know that that's part of the record, but it's a facility where students go and they live. It is co-ed. They reside there. They have mentors throughout the system, including the security guards who are there to help teach them and get them, I think, that the premise is to go along a better path in life than what might have brought them to Job Corps to begin with. Does that help answer your question?
Well, yeah, yes. When you say security guard, I think this is where I'm having an issue. You just said security guard as mentors help them, but so it's not actual security. I mean, I'm confused about that.
No, they have security guards at the facility to make sure that everyone is safe, and they have a gatehouse, which is where they spend a lot of their time and make sure that who is on campus is supposed to be on campus, and that, you know, students sometimes get to go off campus and they have to ask permission to do that. And so the security guards are there to help make sure that there's safety on campus and to see who's coming and going and things of that nature. That's what I know of what the security guard role is, and to do things like make sure at night that the youth aren't out doing things inappropriate on campus, out after, you know, that kind of stuff.
Okay, thanks.
Mm-hmm.
Thank you, Alice.
Wait, but did Commissioner Doosan have any questions?
Oh yeah, no, she didn't. Did I skip her too? No, I think she did not. Did I skip you, Commissioner
It's
Doosan?
okay. I just thought you were reading my mind.
I was not. It's just hard to keep track of you guys when you move. So apologies, Commissioner Doosan. No questions for the investigator. Is that accurate?
That is accurate. Thank you.
Sorry about that. Now you've joined Commissioner Ashby on those I have skipped today. Eventually I will get to everyone. So Alice, thank you. So commissioners, you've heard from the parties and from the investigator. At this point, we would need a motion or motions.
I'll move
Three
to
proposed findings.
I'll move to take them all together, that there are reasonable grounds to believe that respondent discriminated on the basis of sex for a hostile work environment, discriminated on the basis, 2 is discriminated on the basis of sex for discharge, and 3, that was retaliation. And speaking to my motion, it just seems as though it's pervasive. I think the investigator has justified the conclusion that it was pervasive and constant. And although the harassment may have generated responses and emails and questions, it never generated any corrective action whatsoever. That's it.
I think technically we probably should have a second before there's discussion.
Before I start shooting off my mouth, yes.
Is there a second for the motion?
Second.
So it's been moved and seconded. Any additional discussion on the pending motion? Seeing none. So the motion is to find reasonable grounds on all 3 claims. If you say yes, you are agreeing to that, all 3 of those proposed findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Got to see your hand. Thank you. Commissioner David,
Yes.
Commissioner Dusan,
Yes.
2 hands. Commissioner O'Brien.
Yes.
Okay, so the vote is 5-0. All 3 claims, there are reasonable grounds findings, and the commission will be in touch with the parties and counsel. Thank you very much.
Okay.
Thank you
our
all.
next- Pardon me, our next case, E 19-0402, Scott Temple versus State of Maine Department of Admin and Financial Services. This is a reasonable grounds recommendation. Is there anybody here for the respondent?
Yes, Valerie Wright for the respondent.
Valerie, we can't see you. Is that, which is fine. We can hear you. I'm just, oh, there you are. Okay.
There we are.
Okay.
And I just want to say my internet has gone out twice already this morning. So if that happens in the middle of this, I may just try to call in.
Okay.
Okay.
You have 10 minutes.
Okay, thank you. Respondent objects to the investigators for recommended finding of reasonable grounds with respect to disability discrimination, and that's based on failure to accommodate and the complainant's discharge. Complainant was employed for several years as a custodian for the State of Maine's Department of Administrative and Financial Services, which is known as DAFS. There's no dispute that complainant had a degenerative condition and that by 2019, that condition had gotten worse to the point where he could no longer perform his job as a custodian. He went out on family medical leave, and by the time he had used up that leave, everyone agreed that he was not medically able to come back to work as a custodian, with or without any accommodation. So at that point, DAFS followed the state's accommodations policy and began looking for a vacant available position in state government that it could reassign complainant to, a position that he could perform with his medical restrictions, and a position that was equivalent in pay to the job he held. The problem was no such position was available. DAFS looked for one for weeks and could not find one for him. While DAFS was looking, complainant saw a vacant position in state government, and he asked DAFS to reassign him to that position as an accommodation. It was an Office Associate 1 position at the BMV. Now, there's an open question as to whether complainant was qualified for this position, but it really doesn't matter because DAFS never even got that far in its analysis. And that's because DAFS correctly determined that the Office Associate position would have been a promotion from complainant's custodian position. And the reason for this is simple. The Office Associate 1 position was in a different pay range that was substantially higher than the pay range complainant's custodial position was in. Now, to understand this, it's important to understand how state government pay scales work. So let me just spend a minute on that. There are different salary schedules in state government. Each salary schedule has a series of pay grades. Each position in state government is assigned to a specific pay grade on one of those schedules. So for example, complainant's custodian job was assigned to pay grade 5 of the salary schedule for operations and maintenance. And that means that anyone in a custodian position would be paid at pay grade 5. Now, within each pay grade, there are 8 steps. A new employee who's hired for a custodian position at entry level will be paid at the lowest step, step 1 of pay grade 5. After a year, if that employee meets basic job expectations, he'll be advanced to the next step, step 2, and he'll get what's called a merit increase. The next year, the same thing will happen, and he'll move on to step 3, and so on until the employee has worked in the position long enough that he reaches step 8 of pay grade 5, and that's the highest step on that grade. At that point, the employee cannot receive any more merit increases in that job. He's maxed out. He can receive general increases like cost of living adjustments that shift the whole scale, but he cannot earn any more merit increases. He doesn't start working his way up the next pay grade 6. That's not how it works. The position he's in is at pay grade 5. So he's maxed out once he reaches step 8. And that's where complainant was in 2019. He had reached step 8 of pay grade 5. So his only way to earn more money at that point was to be promoted to a job in a higher pay grade. Now, the office associate position was in a higher pay grade than the custodian position. It was in pay grade 11. On a totally different schedule, the schedule for administrative services. Grade 11 also has 8 steps in it. In 2019, complainant's hourly wage that he was making at step 8 of his custodian job was equivalent to approximately step 2 of the office associate's pay grade. So it's true that if he had been reassigned to the office associate job, he could have been brought in at step 2. And initially, he would not have earned much more than he would have been earning in his custodian position. But he would have been eligible for 6 more merit increases over time. In 2019, the wage at step 8 of the office position paid $18.23 an hour. That's about 33% more than complainant was earning at step 8 of the custodian position, where he was making a little over $13 an hour. So if he had been reassigned to that office associate position, he would have gotten the ability to earn up to 33% more than other employees in his custodian positions, By any measure, this has to be considered a promotion. It's definitely not a lateral transfer when you have that kind of a difference in earning potential. The investigator's report concluded that it would not have been a promotion because at first complainant would have been earning about the same. That's ignoring the very significant increase in earning potential. Now, complainant could have applied for that office associate job, and DAFS actually encouraged him to apply for it. But complainant wanted DAFS to reassign him to that job as an accommodation without having to compete for it. And DAFS simply could not do that because it was a promotion. The state's reassignment policy very clearly states that when reassigning an employee with a disability, the state treats everyone the same. It looks for an equivalent position first. And if no equivalent position is available, it looks for positions that would be a demotion. It does not promote employees through the reassignment process. Also, the state's collective bargaining agreements require positions to be posted and open for competition. The state generally cannot simply decide to put someone into a vacant position. The only time they can do that is when they're required to do it by law. The office associate job, if it had been equivalent to complainant's custodian job, then the ADA and the Maine Human Rights Act would have required the state to put him into that job. And so they would have been able to do that because they would have been required by law to do it. But these laws do not require employees to promote someone as an accommodation. So without that legal requirement, DAFS could not simply elect to put complainant into a position that would have been a promotion. So that's respondent's first disagreement with the report. Respondent disagrees with the investigator's finding that the office associate position was not a promotion. But then the investigator went on to say that even if it was a promotion, respondent should have reassigned complainant to that office associate position anyway. And that's our second disagreement with the investigator's report. Now it's clear, and the investigator's report agrees, that federal law under the ADA is crystal clear that an employer is not required to reassign an employee with a disability to a promotion. The MHRA and the ADA contain identical language on this point. Both statutes refer to, quote, reassignment to a vacant position. And that's all they say. The investigator's report assumes that the Maine Human Rights Act does not require employers to make promotional reassignments. But the investigator concludes that the state's reassignment policy is somehow at odds with the Maine Human Rights Commission's regulations. It isn't. The Maine Human Rights Commission's employment regulation says the same thing that the Maine Human Rights Act and the ADA say. Reasonable accommodation may include reassignment to a vacant position. There's nothing in the Commission's regulations to suggest that under Maine law, an employer has to promote an employee with a disability. Yet the investigator has recommended that you find reasonable grounds to believe that DAFS violated the Maine Human Rights Act by not reassigning this complainant to a position that would have been a promotion. How can there be reasonable grounds to believe that DAFS committed unlawful discrimination in violation of the Maine Human Rights Act when there's nothing in the Act or in the Commission's regulations saying that an employer is required to give a reassignment that would be a promotion? The investigator seems to suggest that by foreclosing the option of considering a promotion, the policy is somehow at odds with the regulations, but it isn't. The state has simply chosen not to go beyond what the law requires. And there's nothing unlawful about that decision. So for all of these reasons, respondent respectfully requests that the Commission reject that portion of the investigator's recommendation of reasonable grounds and instead find that there are no reasonable grounds to believe that DAFS discriminated against complainant based on his disability. I'll reserve the remainder of my time.
Thank you. Questions for Ms. Wright? Commissioner Whitworth,
No questions.
Commissioner Ashby,
No questions, thank you.
Commissioner David? You are muted.
Attorney Wright, am I hearing you correctly that finding that there was an obligation to assign him to the open position would be an expansion of the law? Would be an expansion of the main human rights?
You're correct, Commissioner David. That is respondent's position.
That's all.
Commissioner Duson,
No, no.
Commissioner O'Brien?
No, thank.
Okay, you'll have about 1 minute and 10 seconds when we come back to you, Ms. Wright.
Thank you.
Is there anybody here for the claimant?
Yeah, Chad Hansen here on behalf of Mr. Temple.
Go ahead, Chad.
Can you hear me okay?
Yes.
Great. Thanks, everyone. I'm here with Mr. Temple is here virtually as well. Thanks for giving me this opportunity. The investigator's report got it right. The investigator got it right on the law. The investigator got it right on the facts. This is a case, these failure to accommodate cases often in this case do boil down to an employer taking a very reasonable small step in a way that would make a significant difference for an employee, and that's the case here. Mr. Temple was a really good employee for the state. He worked as a custodian. His supervisor reported he was a joy and a pleasure to work with, good customer service, good teamwork. He could work with little supervision. He kept getting merit increases. Unfortunately, he develops these orthopedic disabilities. He keeps coming to work, and now he's using forearm crutches to the point where his supervisor is the one that says, I don't feel like you should be doing this with your crutches anymore. And there was a consensus that wasn't the best idea. So you've got this good hard worker who clearly can't work in this field anymore. And so looks, and he's the one that identifies, he was in an entry-level position with the state, and he identifies another entry-level position with the state. It's in a different department, and it's an office job, which is what he needs at this point. It's something he could do, as set out in the submissions and in the report. Before he went to the state, he had been a warehouse manager at Dingley Press for 13 years. So he had all the skills for this office assistant position. There's really no doubt that he was qualified. And so what the state should have done is just transferred him over. And as far as reasonable accommodations, reassignment, when a person can't do their own job, that becomes the accommodation. Meaning if there's any way for the state to accommodate Mr. Temple, it's going to have to be by transferring him over to an open position, which would have been a win-win-win because the state needed someone in the position and Scott was a good fit. It would have helped Scott stay employed, and it would have been good for everyone else, because what happens is that instead Scott gets terminated, and ever since that time he's struggled and he's been on the outside, essentially looking to private industry to offer him a job, but he's trying to transfer into a new industry, he's trying to transfer into a new job. And that's why reassignment can be so important, because if he were to apply, it's not, initially he's not what they're going to be looking for, because his background is in something else. But if they had just reassigned him, it would have worked and it would have been good for everybody. The state's basis for not doing so is they have a policy not to do so. And their policy takes what I would say is a very extreme view of when an employer should and should not reassign. And in particular, as the investigator points out in the report, there's nothing in the Maine Human Rights Act or in the Commission's regulations that say that a position that, even if it were a promotion, that's something that can't be or shouldn't be offered as a reassignment. The state points to some out-of-district cases, some cases from other jurisdictions for this proposition that they only have to reassign somebody if the position is essentially identical to the position that the person is being reassigned from, which doesn't make a lot of sense because he can't do the position he's in. And so to find a position that he could do that's exactly the same just doesn't make sense. And even the cases that the state cites to, there are no cases that say someone, because this position, there was overlap, so he could have been transitioned and made essentially the same amount of money. There is no case that stands for the proposition that if someone works hard and does well, in the future, they may be able to make more money, that's an excuse not to accommodate somebody. But that's the state's position here. And everything follows from that. In the collective bargaining agreement that the state has, obviously it allows, if there's an obligation to reassign under the law, then the state needs to do it. Well, the state got it wrong. Their policy was so strict, as the state admits, there would only be 2 jobs in the entire state system that, had they been open, Mr. Temple could have transitioned into, based on their reading of the law. And this is the biggest employer in this state and has so many different jobs, but according to their reading, there'd only be 2 jobs, and the chances of one of those being open when a person with a disability in Mr. Temple's position is ready to reassignment is virtually nil. And it also, this policy disproportionately affects the people on the lower end of these job scales and wage scales. Because if someone is higher level and they're making good money, there'd be all sorts of positions under the state's policy they could transfer to. But someone like Mr. Temple, he's pretty much out of luck. But he did identify another entry-level position. And so this makes total sense. The whole idea under the Human Rights Act is come up with a reasonable solution, unless it's an undue hardship. And there would have been no hardship whatsoever in letting Mr. Temple transition over to this other job. So I'd say for both of those reasons, first, it's not a promotion. He could have been transferred to the position with the same pay. The fact that he may have made more money in the future, there's no case that stands for the proposition that that makes it something that isn't a reasonable accommodation. And as far as what the law is, I think an answer to Commissioner's question, there's no case law and there's no findings by the Human Rights Commission that a reassignment has to be in this very narrow band that the state is suggesting. That's not the law. The law is actually, it just says a reassignment may be a reasonable accommodation. So it's far more open-ended than that. And I would suggest, and as the investigator suggested, what you do is you step back and you say, is this reasonable? Can this work? Would this be a hardship for the employer? And if the answers to those 2 questions are no, then an employer should accommodate. And so in this case, the question is, did the state reasonably accommodate this person who clearly had a disability and clearly needed accommodation? And the answer is no. And so the investigator's finding of reasonable grounds makes perfect sense. It's consistent with the law, and it's consistent with the facts and the evidence uncovered during the investigation. And then as far as the discrimination claim, as the case law in the First Circuit and Maine State, if you terminate someone for a reason that could have been addressed by accommodation, that's also disability discrimination, because it's discriminating against someone for something that flows from their disability and could have been addressed. So where this is a failure to accommodate and they eventually terminate Mr. Temple for something that they could have accommodated, that is by definition disability discrimination. So for those reasons, we feel strongly that the investigator got it right. And if there's any questions, I can do my best to answer them. Thank you.
Thank you. Hold on one sec. Okay, questions for Mr. Hanson? Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
Yes, on the first point about whether this is a promotion or not, is it the complainant's position that that's a snapshot analysis, that at the moment of the change in job, we determine whether or not there is in fact a de facto promotion?
Well, yeah, focusing on what are the terms and conditions of the position at that time. Because I think if we make it so strict to say, well, at some point in the future, could the person potentially make more money? I mean, jobs are going to naturally diverge in one way or the other. And there is a Ninth Circuit case that gets into this called McLean versus Runyon, and they suggest it needs to be more holistic. You can't just look at grades, and you can't just look at these sorts of things, because by their nature, they'll screen out pretty much every other position. But yeah, I think what it boils down to is there's no case law to support, and we don't believe that the fact that he could, if he does well, make more in the future would not make this an unreasonable accommodation.
Well, and on that last point, do you think it's legally significant that the promotions in wages that he may receive are in fact specifically merit-based? They're called merit increases, correct?
They are. Well, I think it is. I mean, I think it makes it even more clear-cut, because now he gets into this job, he's making approximately the same as he would have before. And now if he does well, that's to his own credit. He's a person with these physical disabilities who's showing that he can transfer over into this other entry-level position. And if he excels, I don't see why that should be held against him, or why that should be a barrier to allowing him to continue his work with the state. So I think it is significant in that respect.
Do you think that the complainant's case is perhaps weaker if these these future increases are just automatic step increases? Do you think it's a promotion if, for example, provided he worked there for a year, he automatically get a raise?
I think that it makes it, I would still say under the law, especially where the Human Rights Act doesn't have this thing about no promotions is something that they're trying to bring in from other jurisdictions. It's not in the Human Rights Act. But I think that would be one factor to say, well, they're automatic. Then I think it might, it might have some impact. But I would say still in that situation where he's coming in at the same rate of pay, where they're both entry-level positions in their own areas, that it wouldn't be dispositive. And again, going back to McLean versus Runyon, we should be taking, if we're going to apply this whole promotion theory, that we should be taking a more holistic approach. So I still think it doesn't change the result. But I agree that the fact that it is merit-based makes it more compelling to say, just let the guy move over, and if he does well, then he deserves it.
So I'm just going to tip my hand. I find the argument that this is not a promotion to be compelling, but I do want to push against the second part of the argument complainant is making here. Would you agree with me that if the law doesn't require an employer to grant an employee a promotion, if the respondent then says, okay, well, then I just choose not to, would you agree that that's not a violation of the law?
Well, I have a hard time with what these other courts have decided, where I think it starts to get away from the whole purpose of the disability discrimination protections and the whole idea of reasonable accommodation and an interactive process. And I think it gets away from the question, is this reasonable? And I think it gets away from the spirit of the law, which is, can we work together to figure something out? And I think it becomes so regimented that by applying, these tests, and I think unfortunately this is what the state ended up doing, you're just making it more and more narrow and screening out potential solutions, saying we don't even have to consider it till we have two jobs in the entire state system. So I'm uncomfortable with this whole black, kind of bright line, black letter approach. But there are some courts that have taken that approach. And so I think at some point, you got to draw the line. I mean, I think that's a fair point. And it's just a question of where you draw the line. I don't think I don't think the line should be drawn in the place that the state is drawing it. But I mean, you're right that there would come a time when, if that is the law, then there would come a time where something clearly would be a promotion. And then under that reasoning, then it wouldn't be a reasonable accommodation, even if it seems reasonable.
Great, thank you.
Commissioner David, questions for Mr. Hanson?
Yep. Mr. Hanson, what do you say about the observation that we're talking about grade 5 and grade 11? Seems to me on the face of it, they're completely different areas of employment, and you're using entry level as though entry level in every area is the same thing. In fact, you just said entry level in their area. It clearly is a promotion. It seems to me on the face of it.
Well, and that I would go back to that Ninth Circuit case, McLean versus Runyon, which addressed this argument by an employer to say, well, we've characterize these jobs differently. In our system, we give this one a number 5 and this one a number 11. And the question is, well, how is that relevant to what the jobs actually are? And doesn't that give an employer an opportunity just by making more and more grades that you could essentially screen everybody out? Because then almost everybody's in a different grade. And so that gets away from the fact, would it be reasonable for this person to move from this position to this position? And are they sufficiently similar or equivalent? So that case rejected this whole approach about grades, because then what would happen is what it has happened at the state, where they say, well, pretty much if you're disabled in your job and you're in a position like his, the chances that there's going to be a job that we consider to be equivalent is almost nil, because there's so many different grades. So that, I think, is problematic. But where there is overlap with pay, I think that makes it easier. If he was suggesting, hey, I want to move to this job, but you're going to have to bump me up $5 an hour, or my benefit structure is going to be different, or my retirement structure is going to be different, then I think that would be different. But I don't think that just because the state gives these things different numbers, it doesn't have a bearing on the jobs as they actually are.
Well, I might agree, nor does the fact that the hourly pay at the step 8 in grade 5 is the same as the entry level in grade 11 prove that the jobs are the same. The definition of reasonable accommodation is to enable him to perform the essential functions of his job. Accommodate him in a way that allows him to perform the essential functions of his job. And the essential functions of this job were described as lifting, pulling, manual labor. Were they not?
Well,
and he can't do it. Tragically, he can't. But that's a product of his physical condition, not of the state's failure to create a job for him.
Well, that's where I'd say the Human Rights Act, where the legislature put reassignment right into the statute, and then the commission put reassignment right into the regulations, is recognizing that sometimes people find themselves in the position that Scott found himself in here, and that isn't the end of the story, because you've got an employer, and especially a larger employer, that has other positions, and we're talking about open vacant positions. Then the question is, could he perform the essential functions of that other position? He's qualified if he could, and on that front, I think, as we've set out and is set out in the report, he was qualified to do that job. So I think that's a good point. Except for reassignment, we're really focused in on the custodian job. But when that's a non-starter, then the question is, would he be qualified to perform the job to which he's seeking reassignment?
Who's saying he's qualified to perform the job he's seeking reassignment to? He refuses to apply, doesn't he?
Well, he was asking to be reassigned, and this came out during the investigation. They never looked, but they acknowledged in response to questions from the investigator that his prior experience, had they looked and had they learned about his prior experience, that based on that information, that could have met the qualifications for the job. And I would distinguish between being the reassignment, that's the accommodation. An employer saying, oh, you can't do your job, but why don't you go apply with everybody else? That's not, anybody anywhere can do that. The employer isn't offering anything in that situation. They're not enabling the employee to continue working with them. In a situation like this, as I mentioned, where he's coming from this custodian background, even though he's going to be able to do the job, and I think is going to be able to thrive, the chances that he's going to be selected are probably not great. And that's why with reassignment, you just move them over. You do essentially get to cut the line, but that's the nature of reassignment. That's what the Human Rights Commission regulations say. That's what the statute says, is you do this for somebody as a reasonable accommodation. To say, well, you can just apply with everybody else is not helping this person.
You just said, well, you think he can do the job. And the investigator said, well, I think he can do the job. Doesn't the state get an opportunity to look at qualifications and experience and the actual job and make a decision? Shouldn't he have applied?
Well, I'd say two things on that. They did have the chance, and if they hadn't said, based on our based on our policy, we're not even going to consider it because we would only consider it if it was one of these 2 jobs in the whole system. So they did have a chance, but they decided not to. And the assessment of whether someone is qualified for the essential functions, there's multiple factors. What the employer believes is one of those things, but there's other factors as well. And I don't hear that the state is necessarily taking the position that he couldn't do it. But again, it's a situation where reassignment is the accommodation. Them saying you can go ahead and apply to any open positions is, I mean, they're pushing them out and they're saying kind of good luck, you're with everybody else now. And that's where I think, and he didn't apply. So I think you can look at that and say in retrospect, well, maybe he would have applied and maybe it would have been a different scenario. But what we're focused on is the step before that. When he said to the state, I found this position, I think it would be something I could do, I'm asking for you to reassign. And what we're examining is at that point, did the state have an obligation to at least consider whether that would have been reasonable and at least consider whether that would have created any sort of undue hardship for them? And they didn't. And so that's where this finding is, that's where the law was violated. And maybe in terms of mitigating damages or something else, the issue of whether he would have applied and whether that would have worked, that might come into play down the road. But I don't think that that would change the fact that when he asked, the state refused to accommodate him in this way.
Any other questions, Commissioner David? Okay. Commissioner Doosan, questions for Mr. Hanson?
Yeah, I'm struggling with this and trying to figure out how best to articulate the question. I am the area of most concern is this choice, I'm not sure how to describe this, the state saying you can apply, and the respondent deciding not to apply. And when in that context, the employer, because in this instance, the state is the employer, we're treating the state as the employer for both of these positions, both the one the respondent held and for the one that he may or may not have applied for. So dividing out the context for the alternate position, when the analysis of the respondent's ability to perform the functions of the job, when would that analysis have happened in the hiring process? You're suggesting that the state should have done that analysis as part of the request for accommodation, not pass it off to a application process for a position in a different part of the state?
Yeah, and that's my understanding, and this was something that came up during the investigation. I mean, so we have really 2 stages. We have Scott's working with the state to try to figure out a way that he can stay employed. He identifies this position. According to the state from the investigation, what would the process would be if they had said, okay, we'll consider this as a possible reasonable accommodation. They would schedule what they call a meet and greet, which they would facilitate a conversation between Mr. Temple and the people in the department in question. And they would talk, and that department with HR, my understanding is, would determine whether it's something that he was qualified to do. And then if they were determined at that stage that he wasn't qualified for some reason, then under the Human Rights Act, they would have the ability to say, this isn't going to work because he can't do A, B, and C. And therefore, they would have satisfied their obligation because they had the conversation, they considered it, and for some reason, they concluded that it wouldn't have worked. So we're kind of, in retrospect, looking back and saying, well, if they had done what they're supposed to do, what would they have concluded about whether he's qualified? And as set out in the report, based on his 13 years as his warehouse manager position, inputting data, and doing the sorts of things that he would have been doing in the office assistant position, I think the evidence is very strong that he could have done it, he was qualified, and therefore, during that meet and greet process, they would have concluded, yes, he can do it. So then they give him a chance. And then this question about, well, if they're not going to accommodate him and now he's outside of the protection of the Human Rights Act, he could have applied. And then, I mean, another concern I have about this is often with employers, once an employer knows someone has a disability and has gone through this process, there's the opportunity for some concerns to come into the application and hiring process. And we see those cases, and the commission sees those cases, failure to hire cases. And so another reason why reassignment is important is because you're keeping the person in the system, and it's all above board and it's all official. And so another concern about saying you can just go out and reapply from the outside is that they can't unknow what they already know. And so that's another reason where the harm of the state not doing what it should have done in evaluating reassignment is that he's in a much worse position when he's applying from outside.
And your argument is that the duty to analyze the equivalent or identical position for reassignment, you're arguing that the state can't avoid that duty by making a, what, if I understand your position, basically a cursory determination that the position is a promotion.
Correct. It's our position that the Human Rights Act doesn't contain that carve out that says anything that's a promotion is off the table. And what we would say is you still need to evaluate whether it's reasonable and an undue hardship. But alternatively, even if this case law about promotions comes into play, it's our position that they're reading this in such an extreme way that it would screen out, as the state concedes, I think, pretty much any meaningful opportunity to reassign. That they failed, and that they failed in their duty in that respect. And essentially that this policy, which is a very hard-edged policy, they need to adjust that. And if they adjust the policy and say, no, we need to at least consider it and do the meet and greet, then we wouldn't be here.
Understood. Thank you.
Commissioner O'Brien, questions for Mr. Hanson?
No, thanks.
Okay. Mr. Hanson, you will have about 2.5 minutes when we come back to you. And now we'll go back to Ms. Wright. You have about 1 minute and 10 seconds.
Okay. So on that last point, I guess by analogy, I would say, what if he said, I want the Commissioner of Public Safety's job. You need to consider me for that. That's obviously a promotion. We don't have to go through these motions of a meet and greet and analyzing whether this person is qualified for the job if it's clearly a promotion. The characterization of the state's application of the policy in this case is extreme. I don't agree. This was not a close call as to whether this was a promotion or not. The ability to earn up to 33% more in a job is a significant advantage over everybody else in a custodian position. No, none of his colleagues in custodian positions had the opportunity to get 6 more merit increases. None of them did. He would have had that opportunity if he had been reassigned to that job. That alone makes it a promotion. All of the case law says any reassignment to a promotion is not a reasonable accommodation, period. All of it, no matter what jurisdiction you're looking at. Interpreting the ADA or interpreting the MHRA, it's the same language in both statutes. And we've seen many times the law court say if it's the same language in both statutes, you look to what the federal case law is. The federal case law is clear on that.
Ms. Wright, that's your time.
Thank you.
Any follow-up questions for Ms. Wright, Commissioner Whitworth?
But the case law doesn't say that you cannot consider a promotion as a reasonable accommodation, correct?
Yes, that's absolutely correct, Commissioner Whitworth. You know, employers can, if they choose, go beyond what the law requires them to do. And I think the argument has been made by the complainant here that, well, what would have been the harm in doing that? There would have been 2 very significant harms that I can think of off the bat. One is what I explained earlier, which is that the collective agreements all require the state to post open positions and make them available.
Just so you know, Valerie, you're going in and out. So at the moment we can't hear you. We heard the start of what you said.
Okay, let me get closer here. Does that help?
Yes, thank you.
Okay, great. So,
nope, you froze again.
Am I here?
You are, it's very sort of wavy, coming in and out.
All right, I'll try and.
Okay.
Maybe turn off the video.
Yeah, maybe that would help. Not that we don't like seeing you, but maybe it would boost your
Sometimes it
signal.
helps. Yeah,
Yeah.
sometimes it helps. So let's try that.
That's
So, the state would be in violation of the collective bargaining agreement if they elected to do something that they weren't required by law to do that violates the agreement. Okay. So if the agreements require, as they do, that open vacant positions be posted and allow for open competition, the only way we can trump that is if a law requires us to put someone of our choosing into the position. And the law does require it when it's a person with a disability that we're trying to reassign and the position is equivalent or a demotion. You guys hearing me okay?
Yes, we can.
Okay, great. So that's why we can do it when the position is equivalent or lesser. But if it's a promotion, the law is clear across the board that a promotion is not a reasonable accommodation. So would the Maine Human Rights Act allow us to put that person into a promotional position? Absolutely. But the collective bargaining agreements don't. And that's where we would run into one big problem. The second big problem I see with this is that the state employs 10,000 plus people. The state has a lot of requests for accommodation, many of which result in the need for reassignment. The policy is the state's attempt to treat everyone in that position fairly and equally. If the state started offering some of these folks positions that are promotions, then we would be in a situation of everyone saying, well, wait a second, you offered that person a promotion as an accommodation, why not me? And that would get us into a lot of trouble, again, with the unions, because the unions look at whether we're doing things arbitrarily or capriciously. So we have to have a policy that treats everyone the same way. And I disagree with the complainant's suggestion that this is somehow not consistent with the spirit of the law. The law, as we know, is all about providing equal opportunity in employment, equal opportunity. And the state's very committed to that, and that's why they looked very hard to find an equal opportunity for Mr. Temple to stay employed with us. But the laws do not require giving someone a promotion as an accommodation that boosts them significantly ahead of their colleagues, and that's what this would have done. So yes, thank you, Commissioner Whitworth.
That's all I have. Thank you.
Thank you, Commissioner Whitworth. Commissioner Ashby, questions for Ms. Wright?
Yeah, so I understand, and I find compelling your argument that if this fellow had applied for the commissioner's job, it would not be a denial of reasonable accommodation request to not give him the meet and greet. But isn't there an element of brinksmanship happening here? I mean, it's risky, right, to not give the meet and greet because now you're not able to sit in front of us and say, oh, it's the case that he's not qualified for the job or that it doesn't have the same essential job functions. You sort of lose the opportunity to have that argument. And on close cases where, in fact, it may not be a promotion, you find yourself in there's a bit of a problem for the state here, isn't it? Don't you agree?
Commissioner Ashby, I would agree with you if I thought this was a close case as to whether or not this was a promotion. DAS did not think it was a close case. There are closer ones where someone's going to make, they go to the same step. So they go from step 8 in one pay grade to step 8 in another pay grade, but they're going to make a few cents more or $1 more. That's a closer case. And when we have those, they do go through the meet and greet process because it's just not obvious that that's not a promotion. But here it was obvious because the difference in earning potential was so significant. And I know respectfully, I've heard what you had to say. I know you're leaning against me on this, but I really think that this is important. A 33% ability to make 33% more over the next few years. That's an opportunity that his colleagues in other custodial positions in pay grade 5 did not have. And if you say, well, what's the harm in doing the meet and greet? The harm is that they had already determined that he wasn't eligible for reassignment to that office associate position. So to have a meet and greet that's not going to result in a reassignment to that position. How is that helpful to anyone? And suggesting that he apply, it's not blowing him off. It's not saying, you know, we're done with you. It's saying, look, we can't reassign you to that position. We can't just put you in it. But that doesn't prevent you from applying. So if you would like to go for it, go for it. That's what they said to him. So I respectfully disagree with your premise. I guess I would say that this was a close call in terms of the promotion.
So what if the day after he takes, what if you granted him the opportunity to transfer, and the day after he does so, the legislature or the governor imposes a merit increase freeze, no more raises, none whatsoever. Then hasn't he moved into a position laterally, pay-wise, for which he's in the same position he would have been had he stayed in his old job?
There are occasionally merit freezes, as you describe. Those do happen when the state is having budget issues, but they usually are for a year or two, and then they're lifted, and we go back to having annual merit increases. And to your point that you were asking earlier of Attorney Hansen, we put information in the record about the fact that these increases really are virtually automatic, absent that kind of a merit freeze being in place. They really are virtually automatic. You have to be really bad at your job to the point where you're getting disciplined and possibly looking at discharge to not get a merit increase. So yes, temporarily those merit freezes do happen for a year or two, but then they're lifted and then he's back to getting those merit increases.
But the point of my question is to suggest to you that there are any number of contingencies can happen the day after he takes this job. He could not do a good job and not get the merit raises. There could be a freeze. They could change the pay schedule for the job he left, such that there are others that he leaves behind could get increases. I mean, there are so many contingencies before us. Why should we consider the contingencies that you identified, that he has the potential to earn more money, to be a basis to claim that it's a promotion, when the day that he transfers, it's not a promotion at all?
I think because it is virtually assured that if he stays in that job for the number of years, he will get those merit increases. And it is.
Just so you know, Valerie, we can't hear you right this second, and we did not hear the last thing that you said.
Okay, can you hear me
Yes.
now?
Yep, we can hear you now.
Okay, I apologize for this. It's my internet connection is unstable, I'm told. So I forgot my train of thought here.
You were saying it's virtually assured that he will get those raises.
Yes, and it's virtually assured that his colleagues in pay grade 5 will not have the opportunity, let alone, anything based on their performance. They won't even have the opportunity to get merit increases in the future. I understand what you're saying, that yes, of course, the legislature could do something, pay grades could be changed dramatically. I mean, okay, but we have to look at the facts in front of us at the time that we're trying to find this person an equivalent position. And to put them in a position where they can earn a third more than their colleagues is just not equivalent.
Okay, thank you.
Commissioner David, questions for Ms. Wright?
Yes, Valerie, how many pay grades are there?
Oh, gosh, a ton. And I apologize for not knowing off the top of my head. Each salary schedule has 30 something pay grades.
Yeah, I don't mean the steps. I mean the pay grade of which he was in 5, and the job that he was going to was 11. That sounds to me like, on its face, it clearly is a promotion. Maybe if it was from 5 to 6, that would be a closer call.
I don't remember offhand, Commissioner David, how many pay grades those salary schedules had, but I think some of them have 30 or 40. They have a lot. But I think so. I actually agree with Attorney Hansen. Let's not just look at the numbers of the pay grades. Let's look at the bigger picture. And that's why I keep talking about this 33%. I mean, to me, That's the bigger picture. You look at the top of each of these two ranges, the range that he was in and the range that he was going to. He was already stuck at the range he was in at the top at 1371, I believe, an hour. He was going to a range where he was, after a few years, going to make 1823 an hour. So regardless of what those ranges are called, that's a lot of money for someone making that amount of money. That is a huge increase. And that's what, to me, is compelling.
Those income figures also are the basis for retirement contribution percentages and things like
Yes.
that, are they not?
Yes, absolutely.
Yeah, that's all.
Commissioner Dusan, any questions for Ms. Wright?
I think I understand the state's position, so I don't have any questions.
Okay, Commissioner O'Brien, questions for Ms. Wright?
Thanks, all set.
Okay. Thank you, Ms. Wright. At this point, I'm going to mute you and we're going to go back to Mr. Hanson, who has about just under 2.5 minutes left.
Thank you. I'll keep it short. The state's position keeps coming back to this is what they did was the law, and therefore it's defensible. And but that's what we're talking about right now, is whether what they did was consistent with the law. And as I've said before, there's no state law and there's no commission guidance that would suggest that what they did was the law. They're pointing to these out-of-circuit decisions, but it's a situation where it would create almost a perverse, as Commissioner Ashby was pointing out, it would become a promotion if he excels in his job in the future. So I guess the other part of it is, if he were to perform his job in a fairly satisfactory fashion and just keep himself in that pay grade, I know Mr. Temple would have been satisfied just to stay working and at the same pay. He would have been so grateful for that. So if he does the job poorly enough, then it's not a promotion and then he gets to stay in the job. And I think that highlights that this approach doesn't make sense looking at what might happen in the future. And in terms of whether the state's approach to when they will reassign people and when they won't, I think the most important factor is looking at how does this play out. And as the state concedes, of all the jobs in the state system, the way that they're applying this and when they'll consider reasonably accommodating someone and reassigning, there's 2 jobs in the entire state system for Mr. Temple. And the chances of those just happening to be open at the time when he needs a reassignment is so small that I think that is the strongest evidence that the state's approach to this issue is pushing it too far towards we don't do reassignments. And in terms of equality and the collective bargaining agreement and everything else, as soon as the state's position is adjusted to account for the fact that they should have reassigned Mr. Temple, then that's the level playing field, and that applies to everybody going forward. And that would be fair, and it would also be consistent with the Human Rights Act, the language, and the spirit of the law, which is that you should accommodate somebody if you can. Thank you.
Follow-up questions for Mr. Hanson. Commissioner Whitworth?
No questions, thank you.
Wait, did I just call you Commissioner Hanson? For council, sorry, promotion denied for Mr. Hanson. Commissioner Ashby?
No questions. I'm not sure it would be a promotion, by the way.
Yeah,
but no
I just
questions.
thought of that, might not. Commissioner David? Questions for Mr. Hanson?
Yes, I asked you before, and I think I heard the answer. Why didn't he apply for that job? And you said, well, if he applied and it's known that he has a disability and that slips in and you can't really prove it, and he might not have gotten the job. I mean, I'd be a lot more comfortable with the case if the commission was hearing it on the basis of the fact that he's applying for a job for which he's qualified, except for this disability, and that it's a discrimination based on his disability. Why didn't he apply? Why didn't he take that argument away from the state?
If that is in the record, feel free to answer.
And I understand that perspective, but what I would add is that we're looking at, in terms of the state's obligations, we're looking at how they handled the situation at that time. They had and what we're saying, and what I think the law clearly says, is they had an obligation to consider reassignment and to reassign him. And so we're focused on this point in time. And I agree with you in terms of making the facts stronger. it would have been, say, Scott, you should have applied and been turned down, and then it would make it, in terms of looking at the chronology and in retrospect. But what I would stress is that what we're looking at is at that point in time, in August of that year, when rather than reassign him, that the state terminates him. That's the decision that we're looking at. And for the reasons I've said before, I don't think that the fact that he could have applied with everyone else absolves them of failing to accommodate him at that point in time. And so I guess that's how I would respond. But I understand what you're saying in terms of just looking at the whole picture, that it would be more helpful if he had applied and they'd turned him down.
I think Commissioner Davis giving me the thumbs up that he's all set. So Commissioner Dusan, questions for Mr. Hansen?
No, thank you.
Commissioner O'Brien?
No, thanks.
Okay.
Amy, can I follow up to a question?
Sure.
So I don't know, Attorney Hansen, whether you should be bidding against yourself. This fellow identified the specific position that we're talking about, correct? And asked to be assigned to it as a reasonable accommodation, correct?
Correct.
And he got the answer no from respondent, correct?
That's right.
And that's why the claim was made, whether it's a valid claim or not. That's why he's making his claim. He was denied a reasonable accommodation to be moved into the position that he had specifically identified, correct?
That's correct.
Thereafter, the respondent said, you can apply if you want. Go ahead, apply like everybody does. But that's not really relevant, is it, to discussion of whether or not his reasonable accommodation was denied?
I don't believe it is.
I have no further questions.
Okay, last call, Commissioner questions for Mr. Hansen? Seeing none. Okay.
So in that scenario that Commissioner Espy just laid out, the timeline, at what point was if it's in the record, the complainant informed by the respondent that the reason for the no was that they had made a determination that the position was a promotion, not an equivalent position?
I think that was certainly by August. I don't have the report in front of me, but it's certainly by August of that year that was communicated to him in the context, and then he was terminated, but it was communicated to him at that time.
Thank you.
And I think the investigator will definitely be able to give pinpoints to questions like that. Okay, once again, any other questions for Mr. Hansen? Okay, thank you, Mr. Hansen. So we have heard extensively from the parties. Great job. And now the investigator.
All right, good morning, everyone. My name is Kit Thompson-Crossman. I'm the investigator assigned to this case. Sort of jumping off the interaction that we just had between Commissioner David, Commissioner Ashby, and Commissioner Dusan, what I want to focus us on is that this is a case about whether or not the employer reasonably accommodated complainant. And so the timeline that Commissioner Ashby laid out is accurate. The complainant identified this job, said basically identified it as a reasonable accommodation to be reassigned to that job. So the question of whether or not he applied doesn't really bear on the actions of the employer when he identified that he wanted that reassignment as a possible reasonable accommodation. The other thing that I wanted to say is that I interviewed the person who would have done the meet and greet with complainant at the agency that he was applying to. And she was the person who said that, I identified to her what complainant had given me in terms of what his resume would have had. And she said, yeah, those skills might have been relevant to this position if we'd had a meet and greet, depending on some other factors, but that yes, that would have been relevant to the skill set necessary for that position. So it wasn't, I didn't make a determination, is what I'm saying, that he would have been appropriate for that job. That was based on an interview that I did with the hiring manager, basically, for that agency. I think counsel for these parties have sufficiently covered everything else, but I'm happy to answer any questions that you have. You're muted, Amy.
Yep, thank you. Thank you, Kit. Questions for the investigator, Commissioner Whitworth?
I'm trying to put my question into words. So I know that there's been discussion about the opportunity that this candidate or this person would have had to have merit increases over, over the course of employment. But if I'm understanding this correctly, the merit increases are based on performance. So this individual would only have been able to receive merit increases if performance was more than satisfactory, or whatever the rating scale is. And I don't even know if we need to consider that in our analysis, because merit is based on performance. And if performance is, whatever the rating scale is, performance is above average, then that would be a great thing. And the individual then, would have gotten merit based on performance, and that's a good thing. So I'm just wondering if we should even consider that individual's potential for merit increases as part of what we should be considering as we determine reasonable grounds or not reasonable grounds.
I think I can address that. So
Okay.
You're correct that the merit increases are based on performance, and he would have had to be performing at some level designated by his supervisors and the pay scale of maybe the CBA, which we don't interpret, as to what he was getting in terms of an increase. But I think the relevant point for this case is that there were 2 steps that he could have been reassigned to sort of right off the bat that were either essentially at what he was making as an ICW or below it. So he could have been reassigned to a step 1 in the office assistant position and been making less than he was making as an ICW. Or he could have been assigned to a step 2, where I think he would have been making like 3 or 5 cents more, maybe 8 cents more than he was making as an ICW. So essentially the same pay. And then whether or not he moved up depends entirely on his performance. And so, yeah, I didn't take that as a relevant factor in terms of whether this was a promotion or not. If he performed satisfactorily, then yeah, probably he would have been given those merit increases, but that wasn't the question I was focused on in this case. The position didn't look like a promotion.
Okay.
From the evidence that I saw.
Okay, thank you.
Did that answer your question?
Yes, it did. Thank you.
Yeah.
Thank you.
Okay, thank you. Commissioner Ashby, questions for the investigator?
No, thank you very much. Good work.
Thanks.
Commissioner David?
Yes, Kit, what I just heard you say is that you evaluated it and you didn't think it was a promotion. Do you have any hesitancy in saying that it's your proper function to tell the state what is a promotion and what is not a promotion? It's dealing with 10,000 employees. You're dealing with this one specific case and this individual that became disabled.
Sure. Yep. And in this specific case, the position that he would have been assigned to was mathematically not a promotion, given the wages that he was making and the wages that he would have been making in either step 1 or step 2 of that position. He wasn't going to be assigned above that. Okay. So the opportunity for merit increases, as Commissioner Whitworth pointed out, was entirely based on his performance.
That's all.
So mathematically, no, I don't have any hesitation in determining that that wasn't a promotion.
Commissioner David, anything else? You were muted, so I think you said you're all set.
I said, yes, I'm all set.
Okay, yeah. Thank you. Commissioner Dusan, questions for the investigator?
Yes, please. Kit, thank you. Good to see you. The bottom line I'm getting here is that the respondent had being aware of the complainant's disability and his work history, and them being at the step in this process where both parties are considering whether there is an appropriate reassignment available, that once complainant proposed a possible position for reassignment, that respondent had an affirmative obligation to assess whether he could meet the work requirements of that position. Key to me is your conclusion that respondent did none of that, but instead determined that they thought the position was a promotion. So they did none of that analysis. They simply stopped at the assessment that it was a promotion, and that was it.
Yes, correct.
Anything else, Commissioner Dusson?
Yeah, sorry.
It's okay.
Is there, because both parties have stated this in different way in their arguments, is there a prohibition in the law or rules, so maybe this is a Barbara Archer question, against the promotion policy language that the state has in its policies or in its collective bargaining agreement, or wherever the language about not being required, not doing this analysis if the position is a promotion? Is there anything prohibiting that? I've heard Mr. Hanson argue that there's nothing saying that they can. Is there anything saying that they can't?
So not that, if I'm understanding your question correctly, and please let me know if I'm not, the language in, I believe both the law and the regulations are reassignment to a vacant position.
Right.
There's a slight difference between ours and the federal. Barbara, correct me if I'm wrong on this, because I thought I had the whole file electronically and I don't. And so the paper file is in the next room. I can grab it if we need it. But I believe the difference is in the regulations, where the federal regulations say something slightly different than what our regulations say. Our regulations don't have any prohibition on promoting an employee as part of reasonable accommodation. Now, I don't think that was your question. I think your question was, does the law say you can't say you won't promote an employee? Am I understanding you? I'm just trying to keep track of the negatives.
Yeah, right. So am I. Maybe Barbara's a bit, maybe I should wait and ask Barbara, but I heard a very, very early question that stuck with me, I believe from Commissioner David, asking whether this was an expansion of the law.
I don't understand it to be an expansion. I understand it to be an area where our law and our rules don't say one way or the other whether you can or can't promote an employee. And so without a prohibition on promoting an employee, I don't believe there's anything in the laws or the regs that would prevent the state from promoting them if this was a promotion.
I think we're on the same wavelength. It's just, if words are important, and the question here is whether there's anything requiring the state to consider a promotion, not preventing them from promoting someone. But okay.
I don't think there's anything affirmatively requiring them to do that, but there is also nothing that prevents them from doing it in the law or the regs.
Right, yes, okay, thank you.
Sure.
Okay, just making sure there was nothing for Barbara, nothing that Commissioner Dusson you wanted Barbara to address that Kit didn't already get to.
Or nothing that I got wrong.
If council has any elucidating words, I'd be happy to hear.
Well, she has many.
Well, that seems like a promise that I'm not sure I can fulfill. I also am not sure I understood the question. All the law says is that an employer has to provide a reasonable accommodation. One example of a reasonable accommodation is a transfer to a vacant position. All laws are silent as to whether that includes a promotion. The parties have been arguing about what case law says. I think that answers the question. Any other elucidating information I might have has not been requested, and therefore I'm going to be quiet.
She is sage, that one. Commissioner Dusan, all set?
Yes, I'm all set.
Thank you. Commissioner O'Brien, questions for the investigator?
No, I'm all set. Thank you.
Okay. Well, we have had a lot of elucidating from everyone, the parties and the investigator and the commissioners. And I believe we're now at the place where we need a motion or motions.
I'll move that there are reasonable grounds to believe that the respondent discriminated against the complainant on the basis of his disability, reasonable accommodation, and discharge, and that conciliation of the claim should be attempted in accordance with the Act.
Is there a second?
Second.
So the claim in number 1 has been moved to find that there are reasonable grounds, and it's been seconded. Is there any discussion among commissioners?
I'll just briefly, my questions, I think made clear what my position and approach is to this case. And I just want to thank both counsel. This has been fascinating. And I think it's been briefed well and argued well. And I really want to thank you folks. You made it interesting. It's a great, interesting legal issue.
Any other discussion from commissioners?
Yeah, I agree that it's been well argued. I think it's a close case. It's clear to me that the position that he identified was a promotion. That doesn't necessarily eliminate it from possibility. I'm asking myself, what would be the situation with a much smaller employee, a much smaller employer that had a few jobs and there's a vacant position, and yeah, it's a slight promotion, but it's an open position and it can accommodate him and they can evaluate his qualifications. I actually am impressed, and it sounds like I'm just rolling over to the bureaucracy, but I'm actually impressed by the fact that Attorney Wright points out that they got 10,000 employees and that they have an obligation to create policies that are fair and equally administered. And if I had any detection here of any animus to discriminate, it would change my opinion. But as it is, I don't think I can second guess that policy and say, no, that obviously was a pretext to call it a promotion. They just didn't want to accommodate an individual with a disability. So I need to vote no.
Commissioner Dusan, you had your hand.
I think Commissioner David did a very good job of summarizing where I am, and I'll be voting no.
Any other discussion among commissioners? So the motion is to find reasonable grounds to believe the state of Maine discriminated against Mr. Temple on the basis of disability. And if you vote yes, you are agreeing with the reasonable grounds finding. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
No.
Commissioner Dusan.
No.
Commissioner O'Brien.
Oh, I hate being the deciding, but unfortunately, no.
So the motion fails. Hold on, let me just write down. The motion fails. The default finding is no reasonable grounds, unless someone wants to make the motion to find that. And we still have the other claim.
I'll make a second motion that there are no reasonable grounds to believe the state of Maine retaliated against the complainant and for protected activity, and as a result, the claim should be dismissed in accordance with the Act.
Second.
Okay, so the motion is to find no reasonable grounds to believe the state retaliated against Mr. Temple for engaging in MHRC protected activity. Is there any, it's been moved and seconded. Is there any discussion among commissioners?
None other than to say, going back to one, I don't see any need to do that, I'm just going to leave it with the default, but on 2, I will certainly vote in the affirmative.
Any other discussion among commissioners on the pending motion? Seeing none. The motion is to find no reasonable grounds on retaliation. If you say yes, you are agreeing with that pending motion. That no reasonable grounds finding. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
So the finding is no reasonable grounds on the second proposed finding. So both are no reasonable grounds findings. And I want to thank council and the investigator who all did really great work here. The hearing on that case is completed. The commission will send letters to the parties and council.
The next case on our agenda, Kathleen Nealand, the residents in Marriott, and Patricia Wright. This is a no reasonable grounds case. Is there anybody here for the claimant?
Ms. Nealand is here, but we can't hear you right now. Can you unmute? You should have a button that you can hit that says unmute. I am hitting a button. Oh, there, you got it. Okay. Okay, so Ms. Nealand, hold on. You'll have 10 minutes, okay?
Okay.
All right, go ahead.
I was not able to get a lawyer. I tried for 2.5 months. I'm elderly, whether I look it or not. I'm 63 years old. I'm disabled. I'm low income, and I tried very hard to get a lawyer. As the paperwork started coming in, I seem to have dealt with it quite well, with all the response and what was going on and answering and whatnot. Did you say you can't say a person's name?
I did. The only name you can use is Patricia Wright because she's named as a respondent here.
Okay, Patricia Wright. She number one, I had understood on the disclosure that she was not to talk to anybody else about the case. Am I correct in that?
So this is not a question and answer period for you and me. This is just you presenting to the commissioners about the investigator's report.
Okay. I'll leave that one. Okay, a lot has happened since I got the summation from them. On November 27th, Miss Nealand claimed to have fallen while vacuuming the dining room at the hotel and landed on her knees and elbows, which caused back pain as a result. Paramedic reported her fall to CN. So I fell on a vacuum cleaner cord. I body slammed down onto the floor, knocked the breath out of myself, knocked my shoes off, and I had to lay there for at least 10 minutes before I can get my breath. So I finally called Patricia, and she comes in and she says, "What's going on?" I said, "I fell." And she said, "Do you want an ambulance?" And I said, "No." She said, "Do you want Matt Damon?" I said,
Nope.
"No."
No other names.
Boss.
Nope, nope, not using his name.
Okay. And when I came back to work on light duty, Patricia Wright asked me what the doctor said. And I said, the doctor said that I am on light duty. I'm not allowed to vacuum, lift heavy objects. And she takes her hand for a good 5-minute tirade, a lot of swearing, which I don't know. The F word was here all over the place. And she goes, I'm going to the boss and have you fired. And she stomped off. So that did actually happen, and she was actually a witness to this. Okay. As far as the discrimination was concerned, Matt, the boss sent Matt down.
No names.
Sent the boss, sent Patricia.
Okay, that's okay.
Down to ask me if I wanted to do the cooking. And she asked me 3 times. And I knew where the questioning was coming from. And I told her, no, I did not want to do it.
If you're
Which
speaking,
she
we,
reported back full-time cook.
okay, just so you know, there was a pause there where we didn't hear you. So maybe if you could repeat what you just said before now.
So he hired a full-time cook, which he did not need, which led to my hours being cut down to 10 hours a week, because he had to make up 37 hours to give him full-time. And I believe that's discrimination. He was doing my jobs, and my jobs were being taken away from me. Okay.
It looks like you're frozen for a second. So if you're speaking, we can't hear you. And we still can't hear you. It still seems like you're frozen.
I don't know what to do.
No, I can hear you now.
Okay. So I have been having a problem with a coworker that I started having the first day I started working there. She's an elderly person, set in her ways, but she, for some reason, did not like me and made it very clear that she did not like me. And my first day there, I felt somebody looking at me, and the next thing I know, I look up and there's this coworker. Every time I look down and do my job, she's looking up at me. And this continued through my whole shift. She did many, many things that were violence. She stuck her finger in my nose physically and told me that she was going to have me fired from the Radisson Inn for stealing popcorn. Now, the popcorn, I had no idea that I was stealing it. I had gone into the back room, saw the popcorn, asked what it was for, and they just said it's for everybody. This is for 4 or 5 people in there. So I said, okay, I'll take 2 packages, not knowing that I was stealing from the company. Okay, let's start here. Okay, when she's working coffee station, we have 4 different stations in our job: coffee, kitchen, cook, and dishwasher. And each person in each place has a designated place. When the dishes are dirty, they have to bring them out to me. They all have trays. So when they get a chance, they're supposed to bring all the dishes out to me. Well, she decided that she was going to fill her whole cart let me see, I have it somewhere here. 12-foot by 5-foot, three-tier cart, completely full of garbage and dishes, glass dishes, silverware, pushed me right out of the way and started throwing the dishes into every sink area there was, which I have a method in which I do my dishes. Well, she did that 3 different times to me. The third time, the cook, another coworker, I happened to look over at him and his eyes were, he was scared to death. He was trying to climb up the corner to get up onto the counter. Okay, he's African and I believe he has a visa to be over here, and he wouldn't say anything at all, either way, to either party. But the look that he had, he was scared to death. Okay. I told her she was supposed to empty her own cart. She threw a liner at me as she went by. Luckily, I caught it. If not, it would have had to go back into the dishwasher and all the way through. So she was basically just doing it to be aggravative. She threatened me pointing a finger, and we hadn't closed yet the kitchen. It was 9:20, we closed at 9:30, and she pulled all the food out of the kitchen area. And a customer came to me and asked me if I could have she could have some cheese. And I said, sure. So I went to her and I asked her to get cheese for this customer. And she started screaming at me. She was very, very ugly. She followed me out of the restaurant, telling me I need to stock 2 items in the coffee area. She never ever says please or thank you, only talking to me when I've done something wrong. She followed me out of the motel. I don't know if I told you that one, because I didn't stock 2 items. Completely, I was already punched out, and it was a minor thing, and she could have easily done it. We did it for everybody, anyway. Okay. So I went to Matt to complain about these problems.
No names, please.
Okay, sorry. And this was recorded. He asked me what happened. He asked specific questions. I told him Patricia, my sister, could verify for me. She was on vacation.
Miss Nealand, Miss Nealand, that's actually your 10 minutes.
Really?
Yes, really.
Oh, God. Okay.
So I'm gonna see if commissioners have any questions for you. Commissioner Whitworth, any questions for Miss Nealand?
No questions.
Commissioner, oh, everybody moved. Commissioner Ashby,
No, thank you. No questions.
Commissioner David,
Yes, Ms. Nealon, were you scheduled to work on the December 27th after you'd been cleared to return to work without restriction?
Yes.
And you did not, is that correct?
Yes, there's a reason for that. I had asked the boss for another meeting, and he pointed to his chest and he said, I am the boss. I am HQ. And no, you're not getting another meeting. And I said, well, then I would like to file a workman's comp complaint on my wrist because I had gotten carpal tunnel there. So he got very angry with me, told me to go get all my personal items out of the kitchen, out of the break room, and bring them back and sit and wait for him. He had to make 2 calls. He finally comes out to me, and I had to correct him on some of the things he was saying to workman's comp, the comp person. And again, this is all on screen. And he goes, okay. And his face is beet red. He's totally ticked off. And we get through it. And he goes, there's the door. So I automatically assume that I am being fired. So I left. I did not go back.
Okay, thank you.
Commissioner Dusan, any questions for Ms. Nealon?
I have no questions. Thank you.
Commissioner O'Brien, questions for
Okay.
Ms. Nealon?
No, thank you.
Okay. Ms. Nealon, I'm going to put you back on mute and then we're going to turn and to respondent. Ms. Hardevel, I think you're here for respondent.
Yes, that's correct. Good morning, everyone. I'm here on behalf of both of the respondents, Ms. Wright, as well as Residence Inn, which is actually staffed by Pyramid Hotel Group. So I am actually counsel on behalf of Pyramid Hotel Group. My colleague was here earlier, but she had to drop off. To address overall the allegations that were brought up here again, many of the allegations do not actually pertain or are relevant for purposes of analyzing the prima facie cases that we're looking at. Furthermore, the record shows that there was no adverse employment action. Ms. Nealon admits that she was scheduled to work on December 27th and she did not come back to work on December 27th. The hotel contacted her, left messages, and was looking forward to her return. In that respect, it went radio silent. We did not hear anything back, and we kept her on the payroll and were expecting her return until her resignation actually filed after our response was filed in this case. Furthermore, any allegations that have to do with coworkers or Ms. Wright, neither of the individuals mentioned had any type of supervisory capacity or had any control over the terms and conditions of Ms. Nealon's employment. And any of the allegations that were discussed were investigated and were determined to be unfounded. The company worked with her to file workers' comp complaints. And when she left on December 5th, 2019, it was to go to the clinic to be looked at, and that's all we knew, and that was the last that we saw her. In sum, we respectfully request that the commission adopts the investigator's report in full and dismisses Ms. Nealon's complaint, and I will answer any additional questions that you all have to the best of my ability. Thank you.
Thank you. Questions for Ms. Hardevel? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No questions, thank you.
Commissioner David?
Ms. Hardevel, it seems to me an important point that she was scheduled on the 27th, and I heard what she said. You just said that is it in the record that there were attempted contacts verifying that you expected her back on the 27th?
So we had her scheduled for the 27th, but there was no contact made to say, hey, I am coming back on the 27th, and that never happened. We had left messages saying, can you please let us know, update your status in terms of if there were still restrictions and when we could expect.
That's what I'm asking you. There were contacts saying, please contact us, please let us know what's going on. We have you scheduled on the 27th.
Correct. There were contacts made and a voice message was left.
Thank you.
Sure.
Commissioner Dusan, questions for Ms. Hardevel?
No.
Commissioner O'Brien? You should, just to be clear for folks who are watching this, you shook your head. No questions for Ms. Hardevel?
No, thank you.
Okay, thank you. Okay, so then we've heard from the parties and now we turn to the investigator.
Good morning, everyone. My name is Alex Finley. I was the investigator on this case. I don't believe I have anything else that I need to add at this point, so I'll rest on my report. But should the commissioners have any questions, I'm open to answering them.
Commissioner Whitworth, any questions for Alex?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
All set, thanks.
Commissioner Dusan?
I'm good, thank you.
Commissioner O'Brien?
All set.
Okay, fastest presentation. Thank you, Alex. So we've heard from the parties and the investigator, and so at this time we would be looking for a motion or motions.
I'll move that there are no reasonable grounds to believe that respondent discriminated against complainant on the basis of sex and or disability or retaliated against her for engaging workplace protected activity and act protected activity, and the complaint should be dismissed in accordance with the act.
Is there a second?
Second.
Okay, it's been moved and seconded. Is there any discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe discrimination occurred on the basis of sex, disability, or retaliation. If you say yes, you are agreeing with no reasonable grounds on all those claims. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David. I couldn't hear you. Sorry. Nope, you're muted. That's why I couldn't hear you.
So I tried to talk louder.
Yeah, I see that.
Yes.
Thank you. Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
So the findings are no reasonable grounds on all the claims presented. The commission will send the parties and attorneys a letter describing the findings and any next steps available to you under the Maine Human Rights Act. That hearing is completed.
Thank you.
Now we'll go on to our next case, which is E20-0047, Jeffrey Mace Sr., the Maine Department of Transportation. Is there anybody here for the complainant?
Mr. Mace is here. Mr. Mace, just so you know, we can hear you, but we can't see you. I don't know if that was intentional. Either way is fine. You don't have to appear. We don't. Oh, there's two of you. Oh, there you are. Okay. Okay. So you have 10 minutes.
Okay. I'm representing myself. Nice to meet you all. I'm going to start out with what has been. It starts out with investigation should go to my PMFs and to show that there has been a drastic change. I've worked for DOT for 20 years, almost 20 years. And the window of time that you could see the change of the retaliation is pretty evident. As far as what's going on right now is, let's see, on the investigation paper that I just have is they received numerous complaints of video and stuff going on at work that is not allowed. That was never proven. There was no videos or anything of that nature that was even proven. With the pictures, there was pictures taken of unsafe acts that I did report through my counsel through the union, and it was found that it was substantiated and it was illegal to do what they did. In their statements here said that it was okay, but the way it worked out was with the union representation, the stuff has all been proven. I was forced into driving unregistered vehicles. Everything that has been reported does have documentation and other employees that can verify the events. As far as the little red book that we get, the dates that are on the book are not accurate because the date does not, when I found out that through my own investigation, that the date when I found out the proof that it was an illegal act or unsafe act does not represent the date that they're saying this stuff was filed. So you have to look through the book, and sometimes in the book it says, the book is a real small, like a posted note. You can't write down enough stuff in the book. So I go in the book, it says check personal notes. So that is another event that you know, when they say that it didn't match, it does match. It's just, you got to match them up with everything else during my own investigation to find out what was actually right or wrong, what they were telling me to do and making me do. Reports. I did report. It says here that I didn't report it up through the chain of command. I did go to the chain of command. I went all the way up through. Some of the stuff was actually the people in the chain of command that I was reporting. So it was very difficult to, you know, bring it forward. And sometimes it went so far as through the chain of command, went all the way to the regional manager. HR does have documentation of all this, multiple documentation of stuff that I reported, times, dates, supposedly the people that I talked to in HR, and the same people that, in our training and our classes that are from HR admit that they do have records of all this. Again, the PMFs will show, a lot through the investigation of when the change was after the reporting, what I reported. The instances that were unsubstantiated are very great. If you look at what has gone on since the dates of the change, which was when I was a crew leader, and how the crew leader, I got demoted back from being a crew leader, and the reasons for it were not substantiated. Again, it's a lot of further investigation through the notes and through eyewitnesses they're going through the same thing. I don't know how else to say it, but it's more prevalent through each individual to listen to. I guess that's it. I hope we can have somebody investigate and look at it and see what the actual events were due to what is written on the paper here from the state of Maine's defense is not accurate at all. You can, when you read what is said, there's manipulation of the statements and the wording. It doesn't relate to the actual facts. All right, very good, thanks.
Okay, hold on just one second. So questions for Mr. Mace from commissioners. Commissioner Whitworth.
No questions, thank you.
Commissioner Ashby.
No, thank you.
Commissioner David. You're muted.
No, all set.
Thank you. Commissioner Dusan.
No.
Commissioner O'Brien.
No, thank you.
Okay, so Mr. Mace, after we hear from the state, you'll have a little over 4 minutes left.
Okay, thank you.
So Ms. Morrill.
Thank you. Good morning, commissioners. My name is Kelly Morrill and I represent Maine DOT. The department agrees with the investigator's finding that it did not retaliate against Mr. Mace, and the record supports that finding. Mr. Mace worked as a transportation worker 2 from approximately 2003 up until October of 2018. On October 13th of 2018, he was promoted to a transportation crew leader in the department's Rockwood camp. As a transportation crew leader, he reported to the transportation crew supervisor. About 3 or 4 days after he was promoted, he did report that there were uninspected vehicles at the Shirley camp. He reported that to the transportation operations manager. The transportation operations manager instructed him to tell the people at the Shirley camp not to operate those vehicles that did not have current inspection stickers on them. Mr. Mace told everyone but his transportation crew supervisor about that. The transportation crew supervisor then, not knowing that there were uninspected vehicles, did instruct people to drive certain vehicles. It turned out later that the vehicles were actually inspected, but the stickers just hadn't been affixed to the vehicles. When Mr. Mace was promoted to transportation crew leader, he was required to work a 6-month probationary period under the collective bargaining agreement. So approximately 3 months into his promotion, he did have a performance review. At that point, he was not in jeopardy of failing his probation. Then fast forward to, that was in January of 2019 that he had the 3-month performance review. In March of 2019, the department received some complaints about Mr. Mace, about his supervisory style, I guess. The 3 complaints were the one, that he was instructing his crew to perform tasks against the instruction of the transportation crew supervisor. The second complaint was that he was engaging the crew in unprofessional and disparaging conversations about his transportation crew supervisor and the department. And then the third complaint was that he was being demeaning and belittling to his crew members. So he was put under investigation in March of 2019. In March of 2019, he also had another performance review. He was close to his 6-month probationary expiration. At that point, management did discuss performance issues with him, and he acknowledged that there were issues and said that he wanted to correct the issues and do better. So in March of 2019, the department actually extended his probation for another 6 months to give him an opportunity to improve. So his probation was extended to October of 2019. In May of 2019, he had another performance review. There were still continuing issues that were discussed with him. He had also been given a written warning and a written reprimand for a couple of different things during that period of time outside of the investigation. The investigation of him was concluded. In August, he was given notice that management was proposing to fail his probation and return him to his transportation worker 2 position based on the performance issues and the investigation. The department held a Loudermill meeting with him in October of 2019. He attended the Loudermill meeting, and the proposal to fail his probation and return him to his transportation worker 2 position was upheld. So he was returned to that position, and that's where he works now, in his transportation worker 2 position. There's no evidence in the record that the department's actions were retaliatory toward Mr. Mace. They were justified by his performance issues and the complaints that were received that were the subject of the investigation. And those were the reasons why he was returned back to the transportation worker 2 position, for no other reason. So we would ask that the commission uphold the recommendation of the investigator that there are no reasonable grounds. And I'm happy to answer any questions that the commission might have.
Thank you. Questions for Ms. Morrow, Commissioner Whitworth,
No questions, thank you.
Commissioner Ashby,
No, thank you very much.
Commissioner David,
No, thank you.
Commissioner Dusan,
I have no questions, thank you.
Commissioner O'Brien.
Thank you.
Okay, you'll have just over 5 minutes left when we come back to you, Ms. Morrow. So now we come back to you, Mr. Mace. You have just over 4 minutes. If you want to use them, you don't have to. You can respond to things you've heard before.
Sure. Am I all set?
Yes, I'm sorry, go ahead.
Yeah, the task that was asked that I didn't do was not, I was not doing the task that was asked. If it goes back to the spinner on the trucks, for 14 years, we run spinners on the trucks, and there was no word given to take the spinners off, to stop using the spinners. Excuse me, let me repeat this. We used chutes. Supposedly, we were supposed to switch to spinners. I took care of 2 trucks in Rockwood. The trucks kept the spinners on down to Shirley. They never told the Rockwood crew or me to take the chutes off and put the spinners on. That whole year, we still ran the chutes. Now, as far as not doing as I'm told, was not true. It was not what went on. The change in doing the spinners had taken place and was never reported to me as a crew leader, or they didn't even, if that was the fact, they should have come up out of all the applications, and as long as the chutes were on all year, nobody said anything. They kept the chutes on. If that was accurate, somehow we would have had to take the chutes off, or they never told us the difference. And they actually come up and saw the trucks. They watched them work on the road. The spinners did not get put on the trucks. So that is inaccurate as far as doing the duties that were asked with. The belittling was not, it was unsubstantiated. There was nothing said or written or anything for that. I don't know where that come from. They did expend the probation. There was 3 complaints. I'm not sure what the third one is. I didn't get it down in time. But if somebody can explain to me the third one, would be great. Thanks.
So just so you know, we're not really in a discussion here. So your time to present is just what it is.
Okay, thanks.
Okay. Any follow-up questions for Mr. Mace? Commissioner Whitworth?
No questions, thank you.
Commissioner Ashby?
No questions, thank you.
Commissioner David?
Oh, thank you.
Commissioner Dusan?
I have no questions, thank you.
Commissioner O'Brien?
Thank you.
Okay. So with that, I'm going to mute you, Mr. Mace, and now we'll turn back to Ms. Morrell. Ms. Morrell, you have a little over 5 minutes left.
I have nothing further. Thank you.
My favorite kind of presentation. Thank you. Any follow-up questions for Ms. Morrell, Commissioner Whitworth,
No questions.
Commissioner Ashby, Commissioner David?
I just forgot to ask him. He's still employed, is he not, Attorney Morrell?
He is. He's a transportation worker too.
Thank you.
Commissioner Dusan?
I'm all set, thank you.
Commissioner O'Brien?
All set.
Okay. Thank you. And so now we turn to the investigator, Ms. O'Reilly.
Good morning, commissioners. My name's Jane O'Reilly. I was the investigator on this case. I don't have anything to add to the presentations or to what's in my report, but I'm happy to answer any questions.
I forgot that I can ask commissioners, if this is not a vote, I can ask you to raise your hand if you have questions for the investigator and not go through the roll call for that. Any commissioners having questions for the investigator, raise your hand. I see no questions for the investigator. So thank you, Jane. Having heard from the parties and from an opportunity to hear from the investigator, at this point, we would need a motion.
I'll move to find that there's no reasonable grounds to believe that the respondent retaliated against the complainant for activity under the Maine Human Rights Act or the Whistleblowers Protection Act, and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds to believe unlawful retaliation occurred. Any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you say yes, you are agreeing with a no reasonable grounds finding. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner Dusan?
Yes.
Commissioner O'Brien?
Yes.
I got to see your hand.
Yes.
Thank you. So the finding is no reasonable grounds to believe unlawful retaliation occurred. The commission will send the parties and attorneys a letter confirming that finding and outlining any available next procedural steps. Thank you very much.
On to our next case, H21-0199AB, Amy Forsyth v. Saco Falls Management, and A. Willette. Is there anybody here for the claimant? Okay.
There's
Well,
one phone number. There's one person who's called in by phone. I don't know who that is. But I assume that if it was Ms. Forsyth, they would let us know. So I presume that Ms. Forsyth is not present.
so typically in these situations, we go straight to the recommendation of the investigator.
Typically, when there's the objecting party does not appear, the commission votes to adopt the recommended findings.
I'll move that we adopt the recommended findings, that there are no reasonable grounds to believe that the respondents retaliated against or interfered with the protected rights of the claimant, and that the complaint be dismissed.
Second.
Is that Commissioner Doosan?
Yes.
So there's a motion to find no reasonable grounds on all three claims presented. And it's been seconded. Is there any discussion among commissioners? Seeing none. So the vote is the proposed motion is no reasonable grounds on all three claims presented, or rather on all claims presented. And the three stated in Investigator Neal's report. If you vote yes, you are agreeing to no reasonable grounds on all three of the proposed findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yeah, yes.
Thank you. So the findings are all no reasonable grounds. Thank you to the respondents for being here. And we will send a letter to the parties and council with the findings. We have already handled the next case, so there's only one left for this morning.
And it is H210205, Linda Athern v. Michael Mullins. Is there anybody here for the claimant?
Is Linda Athern here? I did see her earlier. I agree.
Yes. Hello.
Oh,
yes,
hello.
Linda
Yes.
Ockman. Yes, I'm on telephone.
Okay.
Because I'm moving. So can you hear me?
Yes, we can hear you. Yep. So
Okay.
thank you for letting us know you're here. We wouldn't want to skip you accidentally. So
I hope not, because I've been looking forward to this.
Okay. Who is this? Linda Athern? And I'm sorry, I've probably
This is Linda. It's Athen. It's Athen.
All right. Thank you for
Yes.
correcting me. Ms. Athern, you have 10 minutes to present your case. And as a reminder, don't use the names of any third parties.
Okay. First of all, I want to say that I'm not very happy with the investigation that you people did on my case. I feel that you didn't ask some people about the situation that I was involved in with Mr. Mullins. I can say his name, can I?
You can, yes. Thank you.
Okay. And I want to set the record straight that, first of all, I did not take out any smoke alarms in this house or garage. And I've been accused of that by you and by him. And Mr. Mullins has not treated me right living in this house. He knew that I had a disability, a brain injury, when I moved into this house. I have been accused by him by taking out the smoke alarms in the house, not letting 3 people come into the house to do work, which is the day that the virus broke out in the country. And he's accusing me of that. And I have rights as an individual to not let 3 people come into my house when something's broke out like that. I was told not to discuss the case with anybody, but he discussed it with other people, and I did not think that was right. That he discussed this situation that we're in with neighbors and other people. Now, He said that I was being rude to people that have come into this house and done work, which I have not been. He has come into my home where I have paid rent and demanded me to get along with people across the street. And I don't think that I should get along with anybody when somebody demands me to get along with a friend. He's accused me of a lot of things, and I'm not going to, the smoke alarms, for instance. I did not take any smoke alarms out of this house, and I'm tired of being accused of it because I did not. Secondly, I want to make the record clear that I have tried to get along with Mr. Mellons, but I will not be made fun of. I will not be called rude, and I will not be called unfit to be around people. I will not do that. I think that is an awful, mean thing to do to somebody, and I will not stand for it. I think it's cruel. And second of all, I do not think it was right that Mr. Mullins went and got 6 people to write libel slander against me in this case. I think that was horrible done. That was cruel and unleading to do to somebody. Another thing, my service dog. I have to put my service dog away in the crate every time he came into my house. And I don't think that's right. I was not treated in a manner that I should have been treated in with my disability. And I don't think it's right. So, no, I don't disagree. I disagree with what the investigation that you did. I don't agree with it, and I'm sorry. Are you there?
Yeah, we're here. I was just going to check with
Okay.
you to see if that's all you wanted to say for now.
Yes, I want to. Yes, right now I do. Yes.
Okay.
I got to take a good deep breath here.
Sure. Hold on one second. So I'm going to see if commissioners have any questions for you. So if you just
You do
hang
that.
on.
Thank you. Yep.
Commissioner Whitworth, any questions for Ms. Athern?
No questions.
Commissioner Ashby?
No questions, thank you.
Commissioner David?
No.
Commissioner Dusan?
I have no questions. Thank you.
Commissioner O'Brien?
Oh, thank you.
I see, I keep forgetting that I can ask you to just let me know. But then again, since Ms. Athern can't see you, it's better if we indicate our positions orally. So Ms. Athern, you're going to have another opportunity to speak after we hear from Mr. Mullins' lawyer. And I'll let you know how much time you have left when we come back to you, okay?
Thank you.
All right, I'm going to put the mute button on again. So you'll need to unmute when it's your turn again.
Yep.
Okay. Ms. Mellenthin, and I've probably pronounced that wrong too.
Good morning, Commissioners. My name is Kelly Mellentine, and I represent the respondent. We agree with the report of the investigator who did a thorough investigation regarding the allegations of discrimination and retaliation. We ask the Commission to adopt the investigator's report by dismissing the complaint. This is not a case of discrimination or retaliation. This is an issue about a landlord-tenant situation which soured, in which the complainant refused to follow terms of the lease. The record speaks for itself in regards to the actions of the complainant regarding removal of the fire alarms, refusal to allow maintenance and repairs, and engaging in hostile and verbally abusive written communication with other parties. Certainly, the parties' lease expired, and after that happened, the parties engaged in further communications in an attempt to extend the lease or engaged in a new lease, which unfortunately did not occur. This occurred over a period of 6 months, and despite those facts, that we were unable to reach an agreement. I think there were a number of allegations that were made today that are outside the allegations that were made in the complaint, so I choose not to address those today. But I ask the Commission again to dismiss the complaint. Thank you.
Thank you, Ms. Mellentine. Was that right that time?
Yes, well done.
Oh, okay, thank you. Questions for Ms. Mellentine? Commissioner Whitworth. Oh, raise your hands, commissioners. Oh, no, wait. Complaining can't see that. Commissioner Whitworth, any questions for council?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
No. No.
Commissioner Deuce, thank you.
Thank you.
Commissioner Dusan?
No, thank you.
Commissioner O'Brien.
No, thanks.
Okay. Thank you, Ms. Mellentine. Back to Ms. Athern. If you have 7 minutes remaining in your time, you can use all of them or some of them or none of them. If you want to respond to anything that came up from Ms. Mellentine. But you have to unmute yourself.
Hello?
Yep, there you are.
Okay. First of all, I want to set the record straight that Michael's lawyer doesn't know really what's been going on, and he's just told her minor things that he has wanted her to know. Secondly, how many tenants come in and tell their clients you have to get along with your neighbors over there? How many people mow your lawn and get dirt all over your car, and when you say anything, the landlord doesn't say anything to that person? Mr. Mullins has put me through hell since I've lived in this house, and I don't care what his lawyer says. She's a liar. And I need to have this man sued for discrimination. That's how I feel about him. He's a friggin' liar. Excuse my language. But he has made my life miserable, and I don't care what she says or anybody else. He's a liar. He's an unfit person to run this household. Simple as that. And that's how I feel. And other people will agree with that. And that's how I feel about this case. It was not investigated properly, and she's full of shit as far as I'm concerned. And
I'm
that's all
sorry,
I have to say.
Ms. Athern, that's unacceptable language to use towards
I'm
someone
sorry.
else who
Excuse
is
me. I
participating
apologize.
in this proceeding.
Yeah. I'm
So,
sorry. I apologize.
If you can speak in a way that is neutral,
Yeah.
you're welcome to
I
continue.
understand. Yeah, I'm fine. Thank you. But this is what happens when people make my life miserable for me. I have a hard time dealing with society as it is with a head injury, and I shouldn't have to explain to you or anybody else that have a problem if you don't know anything about a head injury. And sure, Michael Mullins and his attorney don't know nothing about it. Okay? And that's how I feel, and I have nothing else to say. Thank you.
Okay, thank you. Any follow-up questions from commissioners to Ms. Athern? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No.
Commissioner David?
No.
Commissioner Dusan?
I have no questions.
Commissioner O'Brien?
No.
Okay. I am going to mute you, Ms. Athern, because your opportunity to participate is finished. Ms. Mellentine, you have lots of time left as well if you want to use some or all of them.
I have nothing further.
Understandable. Questions from commissioners for Ms. Mellentine? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No, thank you.
Commissioner David?
No.
Commissioner Dusan?
No.
Commissioner O'Brien?
No, thanks.
Thank you. So then we turn to the investigator. Back to Alex.
Hello, everyone. My name is Alex Brindley. Still, I was the investigator in charge of this investigation, and I don't think I have anything else to add at this point, but I'm open to any questions. Thank you.
Questions for Alex? Commissioner Whitworth?
No questions.
Commissioner Ashby?
No questions.
Commissioner David?
No, all set.
Commissioner Dusan?
No, thank you.
Commissioner O'Brien?
No, thanks.
Thank you. Thanks, Alex. So at this point, we've heard from the parties and the opportunity to ask questions to the investigator. We need a motion.
I'll move. There are no reasonable grounds to believe the respondent discriminated against complainant on the basis of disability or retaliated against the complainant, and that the complaint should be dismissed.
Is there a second?
Second.
Commissioner Whitworth. Yep. So there's a motion. It's been seconded. Is there any discussion among commissioners? Seeing none. The motion is to find no reasonable grounds to believe that the respondent discriminated against complainant on the basis of disability or retaliation. So if you say yes, you are agreeing with both of those findings. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes,
Got to see your hand. Thank you. So the vote is to find no reasonable grounds to believe that unlawful discrimination or retaliation occurred. And the commission will send the parties and council a letter reviewing that recommendation. And that finishes our hearing agenda for this morning. So it looks as though we have a little bit of time. I'm sorry, Ms. Zulette. You're muted. You're still muted.
Hi, can you hear me?
Yes.
Okay, I was waiting for our case, Amy Forsythe versus Saco Falls Management and myself.
Yes. Your case was decided. The commissioners called it and the complainant was not here. So when that is the case, even though I saw you and I saw that the council, that Ms. Taberge was
Yes,
here,
I saw her.
when the complainant's not here and they're opposing the finding, we don't ask the other side if they want to present something. So I appreciate you being here, but that's
Okay.
our typical practice. So the case was decided and there were no reasonable grounds findings on all claims.
Wonderful. Now, are there any repercussions that she?
I'm sorry?
Are there any repercussions that the claimant will suffer for this horrendous experience?
I'm happy to answer questions for you, say by email or by phone, but we've
Okay.
finished our morning's hearing agenda, which
Okay.
is really all that we do at these hearings is hear cases.
Simple enough. I appreciate all of your being there for us.
Thank you.
Amy, back here at noon?
Yes, back here
Thank
at
you.
noon. Thank
Get some
you. Thank
lunch.
you, commissioners.
Mommy's baby. Mommy's baby. Oh, yes, you are. Oh, yes, you are. Puppy, mommy's baby. Okay, go get your toy. Go get your toy. Go get your toy. Mommy has something to do. Go get your toy or lay down and be good. What are you doing? Stop licking me. Stop it. Oh, it's okay. Calm down.
Excuse me, Kim Norwood, could you
Yes.
please mute yourself?
I'm sorry.
Could you please put your Zoom meeting on mute? We can hear everything that's going on in the background. Thank you.
Is it okay to unmute now? I can't hear.
Okay, can you hear me now? Hello?
Yeah, I can. Can you hear? Hi, can you hear me?
Yes, yes, yes.
You sound okay. Okay.
Okay. Okay, my name is Gary Manuel, and I'm calling concerning the conference today.
Yeah.
Okay, am I at the right area?
Oh, you're calling in. You must be one of their cases.
Amy, you're
Yes.
muted. Amy,
Hello?
you're muted.
I am, thank you. Apparently, I've been talking to you all along, but I've been muted. Sorry, thank you,
Oh.
Alice. I was
Okay.
responding to Ms. Norwood saying, yes, but you're going to stay muted for now. And I was responding to Mr. Manuel saying, yes, but you're going to stay muted for now. I had a whole conversation with all of you. But for now, I'm going to keep everybody muted and I will let you know when you should unmute. Okay?
Okay.
Okay, okay, okay.
Thank you, Alice. Oh, look, other people messaged me also telling me I was muted. Thank you to all of you.
Hello,
Hello.
should we stay on mute while this is pending?
Yes, we will definitely let you know when we are ready for each of you.
Thank you so much.
We'll get started in just a second.
Are we ready, Amy?
We are.
Okay, so it's 12:01. Good afternoon. I'm Deb Whitworth, and on behalf of my fellow commissioners, welcome you to the second half of this meeting of the Maine Human Rights Commission. Before we proceed with the business of this afternoon, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. We have provided the agenda with a link to those who have joined us today, and it included the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time period, and the commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the, let's see, I lost my place. to provide the most relevant arguments to the case. The time limited is 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions, and please introduce yourself as you come to the podium.
And before we start any cases, just also a reminder to all the people presenting that we don't allow the use of the names of any witnesses or third parties. The only names that you can use are people who are named as respondents. So no witnesses' names, nothing like that.
Okay, and the first case that we will hear this afternoon is H21-0260AB, Gary Manuel, the Waterworks Department, and Caleb Group. This is a no reasonable grounds recommendation, so we will hear from the claimant first.
So Mr. Manuel, you have 10 minutes to present your case.
Okay, well, today's date is the 11/7/2021. Am I correct? It's the 7th day, right?
Today is the 8th, but this is not a conversation. This is your chance to present.
Okay. Well, I have 3 things. One is the fictional error. The Maine Human Rights Commission summary of case states that my case was about not being allowed to have guests and smoking indoors, but that wasn't what my complaint was about. Mr. Manuel submitted 2 complaints, one being denied his right of having knowledge of which tenant at the waterworks stole his mail from the mail area. The second complaint was about being denied his right of the opportunity to ventilate his dwelling from heat exhaustion. These are the only 2 issues that my complaints on the 18th and the 22nd of June was about, where the Maine Human Rights Commission stated it was differently. That's an error right there. The second thing was a fictitious summary. Okay, upon the interview of the property manager, stated that she watched my mail for about 2 weeks, but I received my mail on the 6th of that month. Notice, and then I put in a notice that my mail was stolen on the 9th and reported it being stolen to her on the 11th. That's not even a week. Just the proof I sent in, it shows that, where, listen, she was lying within her statement. Waterworks, the Caleb Group has a professional security system, LT security camera. But
so you can't use the names of any other company.
Okay. Sorry about that. But the date of my stolen mail, the video footage was unrecoverable. We all got security systems, especially big businesses. That don't make that's kind of unrealistic. Okay, the property manager stated that I came to her, reported my mail had been stolen, but I didn't come to the property manager, I emailed her. The property manager stated they tried to keep a safe environment for tenants, but the main entry door has been broken for over 6 months. tampering, allowing others to come into this dwelling to tamper or to violate other people's privacy. Okay, now, the third issue I have is, and that's interpretation of the law. The Maine Human Rights Commission Regulation Chapter 8.09 B2. No interference with tenants' enjoyment of the dwelling. Well, the waterworks, the Caleb groups denied Mr. Manuel the right of the opportunity of ventilating his dwelling from heat exhaustion. Furthermore, the waterworks, the Caleb group, has video cameras which can be viewed from their home. I reported the crime for 11/20/21, but Aaron waited until she arrived in the office for 12 to view the camera footage. I was treated indifferently than other tenants has been, because the same thing happened not so long ago, and she told them who took their mail. Now, I think I have been treated in a biased way by the Maine Human Rights Commission, because I was not treated equally in the conference fact-finding meeting. Why was I not notified by mail of the meeting date? In all other cases, I was mailed out a letter from the Maine Human Rights Commission informing me of the conference fact-finding meeting date. I was not this time. My complaint was clearly written, but was not given proper consideration or proper presentation within the investigation report. I supposed to have been notified by U.S. Postal Service mail of the Maine Human Rights Commission conference meeting, which I wasn't. And the last thing was one of the questions that was asked of me was not even in my case. And here we go right here. And because they wanted me to respond to certain questions. And that was on towards the answers of Maine Human Rights Commission investigation, Alice Neal question, the response. And she gave me a couple of questions. One of the questions, it just wasn't in my complaint at all. And I answered back, letting her know it was 13. Your response of stealing your mail after you mailed it from the U.S. Post Office. Well, that wasn't in my complaint. I didn't note that nowhere in my complaint, and that's an error. But the thing of it is, the reason why I think it was an error, because listen, my complaints is not being considered in a fair and equal way. So, I mean, it's simply there. It's from you guys sending it to me, where I didn't, in none of my complaints, I cited that within my case, that my mail was still stolen from the United States Post Office. And that's it. Oh, listen, is this being recorded?
This is being recorded.
Okay. Now, listen, will I be able to get a copy? Can you email me a copy once you get, because I need this for my...
I will be happy to answer procedural questions, but not during the argument. I'll be happy to answer those at a different time. Right now, we're in the middle of the hearing.
Okay, so can I leave the meeting now?
You are entitled to leave the meeting. You might want to remain to hear what the other side says in response, because you're going to have a chance to speak. You have about 2.5 minutes left if you want to respond to what they say.
Well, upon the meeting that I missed, Aaron already spoke and gave her testimony
Okay,
of,
hold on. First of all, that's, and I think I didn't catch this before, you keep mentioning a name of somebody who is on this call, but is not a party, so you can't use their name, right? That's the first thing. The second thing is, whatever happened during the investigation, right now, our commissioners are going to vote on whether there is discrimination or not. So you don't have to stay, but you might want to stay.
okay, wait a minute. One thing is confusing me. Aaron, she's supposed to be a part of this because when I put in a discrimination claim, I mentioned her name. So,
Mr. Manuel, this is, we respect who the party, the complainant names in their complaint. And the fact that you mention someone else doesn't turn them into a respondent. So you can't mention her name because she's not a party in this case. She may have been a party in some other case, but she's not a party in this case.
okay, well.
And I'm not going to argue it with you now.
I know, but I'm having a problem. The last time when y'all had a meeting that I missed, how come she was allowed to give a testimony?
I don't know, and we're not going to get into, you have made the point that you don't think the investigation was done and that you weren't included. I heard you make that point, but this is not a conversation between you and me about what you think went wrong. You can make your points to the commissioners, but not procedurally between you and me. You used about 7.5 minutes of your time to make a presentation. You have up to 10 minutes. If you want to use the other 2.5 minutes now, you can, or you can wait and use that after you hear from the respondent. You also asked if you can go. You can. You don't have to stay. But the commissioners are going to vote on the case either way.
Okay. Well, I gave my presentation. And then you said for any other information, I need to call you back at another time.
I did. Right now, I'm going to put the phone on mute for you, and I'm going to let the respondents have an opportunity to make a presentation, just like I gave you a chance to make a presentation.
Okay. Thank you so much. And I'll talk to you at another time. I'm out.
Okay. Thank you.
Okay.
This is where we would look to the respondents. Is there someone here for Waterworks Development and the Caleb Group?
Yes, Attorney Aubrey Russell.
Okay, Ms. Russell, you have 10 minutes.
Thank you. The respondents agree with the investigator's report. We do want to spend a little time responding to Mr. Manuel's arguments. Waterworks is a building that provides 35 single occupancy units to its tenants. It's managed by the Caleb Group. It has a property manager on site at times, although the property manager has not always been on site during the pandemic as a result of trying to keep people remote and keep people safe. They've also at times had a resident service coordinator at the property. I think it's become clear to everyone involved in this case at the Waterworks that Mr. Manuel believes that he's being discriminated against. And based on one or more of his protected classes, the Waterworks and the Caleb Group deny discriminating against Mr. Manuel and deny retaliating against him based on his race, color, or his disability. Mr. Manuel's complaints include several allegations against the respondents. However, many of them have been previously investigated by the commission. Mr. Manuel brought up today an issue regarding being denied the ability to ventilate his unit from heat exhaustion, and we believe that's an issue that was previously addressed by a different complaint that the commission already found no reasonable grounds for. It's our understanding that there are really 3 issues that the commission was addressing today with regards to possible alleged discrimination. Mr. Manuel, I don't think really touched on 2 of those, and so we're not going to put argument into those with regards to being allowed to smoke in his unit, as well as being allowed to have overnight guests. However, he did put on some argument about the mail, and so I just want to be clear about our position on that. The property manager did receive a complaint from Mr. Manuel about his mail being stolen from the mailbox area in April of 2021. He did request to be able to review the video footage on that. They do have video cameras at the property. When that was requested, Ms. Gary attempted to view that video footage. Unfortunately, the program needed an update.
Ms. Russell, I'm going to ask you also not to use the names of any third parties.
Sorry. The property manager did attempt to view that footage. It's the policy that they don't allow tenants to view the footage, but they will review it. And if there's any information they can provide to the tenant or to the police for an investigation, that they would do so. At the time that the property manager went to review that footage, the program needed an update. She started that update, and the reason that she was unable to get back to Mr. Manuel until the next day is because it took that long. It took until she was done her work that day for the update to occur. Unfortunately, when the update occurred, it did delete the footage. She contacted the company that has the cameras, hoping that they would have some way to recover that footage. But unfortunately, because it's not saved to a cloud, they were unable to recover the footage. She explained this to Mr. Manuel. She also suggested to him that he contact the post office as well as the police department. A police officer also contacted her, and she worked with that police officer at the time. Ms. Gary felt, or the property manager felt, that she did what she could to assist Mr. Manuel with trying to figure out who took his package. Yes, Mr. Manuel pointed out that his package may have only been sitting there for 5 days. The property manager had stated that she believed it was 1 to 2 weeks in her response. She didn't have the exact time frame of how long that package had been sitting there, but was trying to make the point that it was there for a period of time, and that her and the resident service coordinator had both asked him to pick up the package prior to it being taken by someone. The respondents feel that they have not retaliated against Mr. Manuel, and that they have not discriminated against him. The property manager went so far as to say that she feels as though she goes above and beyond every time she hears from Mr. Manuel, because there have been so many complaints filed previously, that she makes sure that if he comes to them with a complaint, that she follows up and investigates fully each time. And if he talks with her, she makes sure that she does whatever she's going to say she's going to do and follows up as fast as possible. And she's really trying to provide Mr. Manuel with the best living situation possible. And that on a day-to-day occurrence, she has a very amicable relationship with him. He says hi, she says hi back. He knocks on her window, and she says hi to him. And until these complaints come each time, she really has no indication that there is an issue with him. So again, they deny that there's been any discrimination or retaliation, and they hope that the commission will follow the recommendations of the investigator. Thank you.
Thank you, Ms. Russell. Any questions from commissioners for Ms. Russell? Actually, no one's on the phone. Commissioners, if any of you has a question for Ms. Russell, raise your hand, let me know. I do not see any questions from commissioners for you, Ms. Russell. Thank you. So then we would turn to the investigator. It's Alice, I believe.
Good afternoon, commissioners. I'm Alice Neal. This case was mine in terms of the investigation. I just want to clarify a couple of things. And I note that Attorney Russell has already touched on the fact that complainant has said today that there were only 2 allegations that he was alleging as part of his complaint. We've had extensive complaints from him alleging a myriad of issues. Almost all of them had been dealt with by 2 prior investigations that had happened. And one of those included issues with Mr. Manuel being able to open his door, which is related to the ventilation issue. One of the things that complainant said today that really seems to have frustrated him is that he didn't get a copy of my notice for the Issues and Resolutions Conference by mail. I think the commissioners probably know this, but just as way of explanation, we don't have a requirement on how we send notices to parties. And since the pandemic, we've been sending a lot of notification just only by email. Mr. Manuel is clearly on his email all of the time. He communicates with me, and he even asked questions leading up to the conference when I said, I need this information from you, the non-disclosure agreement, before the conference on Wednesday. So he knew that there was something coming up, and he clearly had notice. I just wanted to inform the commissioners that there wasn't any way that I was trying to hide the ball on that or not give him a chance to participate in the investigation. Other than that, I haven't heard anything from the parties today that would change my recommendations, and I would happily answer any questions that you have.
Thank you, Alice. Commissioners, any questions from Alice? Raise your hand. For Alice, that's what I meant. Commissioner questions for Alice. I do not see any. And I say thank you, Alice. So commissioners, you've heard from the parties and the investigator, and at this point we would be looking for a motion or motions.
I'll move to accept the recommendations of the investigator on both counts. No reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, race, and/or color when it treated him differently in the terms and conditions of his housing, and that there are no reasonable grounds to believe that the respondent retaliated against the complainant for asserting his rights under the Maine Human Rights Act, and the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds on all claims. Any discussion among commissioners? Seeing none. Then at this point, so the motion is to find no reasonable grounds on all claims presented. If you say yes, you are agreeing with that. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Doosan.
Yes.
Commissioner O'Brien.
Yes.
So the findings are no reasonable grounds on all claims presented, and the commission will send the parties and attorneys a letter confirming that those findings, and thank you for being here. At this point, we're moving on to our next case.
Commissioner Whitworth, I'm required to recuse myself from H210268AB.
Okay, we will make a note of that in the minutes.
Okay, so H21-0268 AB, Heather Bain v. Lewis Albert and Michael Albert. We have two different findings here. Since one of them is a reasonable grounds recommendation, we will hear from the respondent first. Is there anybody here for Lewis and Michael Albert?
Good afternoon, everybody. Josh Ramlett. I'm here on behalf of the respondent, Michael Albert.
But not Lewis Albert?
That's correct.
Okay.
But there was no reasonable grounds finding as to all counts to Mr. Lewis Albert.
I see, thank you. Go ahead, you have 10 minutes.
All right, thank you. So there's a lot in the investigator's report that my client and I agree with, and that's the no reasonable grounds finding as to all counts with respect to Mr. Lewis Albert, but also the no reasonable grounds findings as to Michael Albert on the following grounds: discrimination on the basis of receipt of public assistance, on the basis of family status, and on the basis of MHRA retaliation. The investigator found no reasonable grounds on each of those, and we would ask that the commission affirm in that respect. There is one part of the investigator's report, however, that we do disagree with and we do object to, and that is the reasonable grounds finding with respect to the disability discrimination for Michael Albert. So to get to the end of the case, so to speak, on that count, there are three things really that have to be established. Number one, the complainant is a person with a disability as defined by the Human Rights Act. Number two, that the dog at issue here is an assistance animal as defined by the Human Rights Act. And number three, that there has in fact been discrimination within the meaning of the Human Rights Act. And from our perspective, the record is lacking and insufficient on all three of those grounds with respect to the disability claim. And I'll address each one of those in a little bit of detail. So first, with respect to the complainant's status as a person with a disability, the investigator's report acknowledges that the record is far from clear on this point. So then we have to ask ourselves, what is the evidence in the record about the complainant's status as a person with a disability? Well, we have the application for the housing that the complainant submitted. And just by way of information, this housing complex is one that is federally subsidized through the USDA Rural Development Program, which is similar but not identical to the HUD program. But anyway, it's federally subsidized. So in our application for that, there's a box to be checked for whether or not the applicant considers themselves qualified for a handicapped or disability subsidy. We have the complainant checking no on that. Okay, so then what else is there for evidence in the record about disability? We have a doctor's note dated December 15th of 2020. It references a condition, but it does not give any evidence or detail one way or the other about whether or not this condition meets the statutory criteria for disability. It's a condition that certainly can be a disability under the statute, but by the same token, there are also many, many people out there in the world who have this condition and who are not disabled within the meaning of the statute. So that doctor's note does not tell us one way or the other whether or not we check all the boxes for disability. So then what else do we have? Well, we have the complainant's testimony at the Issues and Resolutions Conference. And actually, this is set forth in the investigator's addendum to the report, where you can see in some detail what the complainant herself had to say about her status of having a disability or not. And she said twice that she, at least as of the time of that conference, which was August of this past year, had not completed diagnosis. She was apparently talking to somebody, trying to get some diagnoses figured out, but it appears that nothing had been finished as of August. And in fact, she goes on to concede and acknowledge to the investigator that I'm not technically a person with a disability. And that's really the extent of what we've got in the record. So we've got nothing affirmatively establishing, yes, this qualifies as a disability. But to the contrary, we have an affirmative representation from the claimant that she does not meet that criteria. So that's the first issue, is whether or not she meets the disability definition. The second issue is whether or not this dog at issue in this case meets the statutory definition of assistance animal. And the statute tells us that for it to be an assistance animal, it has to be, quote, determined necessary to help mitigate the effects of a disability as determined by some form of healthcare provider. Well, again, what do we have for evidence in the record that this dog was determined necessary to mitigate the effects of the disability? Number one, we don't have a disability, but beyond that, if we look at the doctor's note that was submitted in December of 2020, it doesn't say that a dog is needed to mitigate any condition. It says, please allow somebody to have a dog for their condition, but it doesn't give evidence one way or the other about how that actually helps the person or whether it mitigates the effects of their condition. But beyond that, again, turn to what was testified to by the complainant at the Issues and Resolutions Conference. And again, this is reflected in the addendum to the investigator's report. So as the complainant herself acknowledged, when she first moved into the complex in early November, she did not have the dog at that point in time. She had previously owned the dog, but in fact had given it away before she ever moved in, which tells you right there that she, at least as of the time she gave the dog away, was able to cope with her condition without the use of this dog. So then at some point, obviously the dog comes back into the picture and moves into the apartment with her. Why did she move the dog back in? Well, she told the investigator that I had given the dog away, but ended up with her back when I had an inkling that my children were going to be living with me. So that's the impetus for why she wanted the dog, not because of to ameliorate any condition that she had, but because she was anticipating that her children were going to move in with her. As we know, and as set forth in detail in the investigator's report, that never happened. To this day, her children are still not living with her. So to the extent that the children might have played an impact on her need for a dog, that hasn't happened yet. So we don't check the box there. And nor do we have anything in the record to suggest that from the time we received the doctor's note to the present that her condition is substantially worsened as compared to when she had given the dog away and first moved into the complex and did not have the dog. We don't have anything to show that in those two timeframes, anything changed with respect to her condition. So that's the dog's and assistance animal. My last point is discrimination. So even if we get past those two issues, there's been no discrimination here. First and foremost, I have to point out that the complainant has at all times had the dog whenever she wanted the dog with her there. She's never been evicted. Nobody's removed the dog. She's been allowed to have the dog. But in terms of timing here, this is important. The complainant told the investigator that when she first moved in, she didn't tell the respondent anything about the dog or about any condition. And that the first notice that the respondent would have had about a purported assistance animal would have been the December 15 note from the doctor. So anything before then, clearly there couldn't have been any discriminatory animus if they had no reason to believe that there was any mental condition that might warrant having a dog. After the doctor's note, what do we have? Okay, we have continuing lease violation notices related to non-payment of rent, noise complaints. We only have one related to the dog, but that was also related to dog feces being left around, dog barking and things of that nature. Now, admittedly, there have been a number of back and forths between the complainant and the respondent's representative about the dog. But I think something important got missed in translation here. It's not you can't have the dog because it's a pet. That's not the intent of what was being said, and that's not what the respondent was trying to get at. The respondent was trying to say, okay, if you want to have an assistance dog, you need to be recertified through our HDA program or our USDA Rural Development Program. You need to resubmit the application and the paperwork that we submitted to the federal government because we have to have this paperwork in line. And included in that is a disability verification form. So come down and submit the paperwork, and then it will be evaluated at that point in time. And there's numerous instances where the respondent's representative tried to work with the complainant's caseworker to get that paperwork recertified. The complainant never did any of that. To this date, the complainant has never complied with the request to submit verification of the dog as an assistance animal or the existence of a disability. Now, under the Human Rights Act and the regulations, it's very clear that if somebody is making an inquiry related to a disability on a form that is approved by a federal, state, or local governmental entity for legitimate purposes, that's not discrimination. And that's exactly what we've got here. We've got the respondent saying, we want you to fill out the recertification form. We want you to fill out the verification of eligibility form. Those are HUD-approved forms by the federal government. Come fill them out.
Mr. Randall.
I'm sorry.
I'm sorry to interrupt you, but technically any other federal agency, and I should have caught this before, all those federal agencies that you've mentioned are third parties. So if you could not mention them, not mention their names.
I'm sorry, my apologies.
And also you have like
event,
10 seconds left.
Okay. So that's not discrimination in my view. Lastly, there is evidence in the record of the dog creating other problems such as feces running loose, scratching at other people's doors, and causing noise complaints through barking. So even if she were entitled to have the dog, the respondent would have been justified on those grounds. But like I said, she's had the dog, she continues to have the dog. So with that, I will end because I understand that I'm out of time, but I'm happy to answer any questions that I can.
Thank you, Mr. Randlett. Commissioners, any questions for Mr. Randlett? Raise your hand and I will call on you. Commissioner David.
Attorney Randlett, did they ever ask the doctor? You quibbled with the fact that the note just said that she needed the assistance of an animal to mitigate the effects of the disability, and then you said she didn't prove how it mitigated. Don't they have to ask the doctor what he's talking about?
Well, that's a very great point, and that highlights why we needed to have participation from the complainant here, because under HIPAA and medical privacy rules, the doctor can't speak with third parties about the complainant's health care absent some sort of consent or authorization from the complainant. So that's what the respondent was trying to accomplish. Here's the authorization or the verification of disability form. Fill this out. Let us get the information that we need. We will consider it. But there would not have been any possibility under confidentiality laws for the respondent on its own to go to her healthcare providers without some form of authorization or release and to get information from that medical provider. So it requires participation from the complainant, which has been lacking at every step of the way.
Muted. Commissioner David, anything else for Mr. Randlett? No. Any other commissioner questions for Mr. Randlett? Seeing none. Thank you, Mr. Randlett.
Thank you.
And is there anyone here for Heather Babin? I probably pronounced that wrong. I don't believe she is in the meeting. So we heard from the respondent, the complainant is not present. So then we would turn to the investigator.
Good afternoon, everyone. My name is Kit Thompson Crossman. I was the investigator assigned to this case. I will say this was a pretty close one. And I guess since complainant isn't here, what I would say is there were a couple of instances after she submitted the doctor's note where she was basically told that the doctor's note didn't matter. She got at least one other lease violation after the doctor's note was submitted, and there was a phone call between complainant, caseworker, and Mr. Albert, where he basically told her that the doctor's note didn't matter because she hadn't certified that she was disabled, which is not the requirement for having an assistance animal. The doctor's note does say she needs a therapy dog to mitigate her depression. It's not technically asking for an assistance animal, but I think that gets the gist across. Attorney Randlett is correct that complainant didn't recertify and didn't fill out that paperwork, but she did submit that doctor's note, which is what's required to request an assistance animal in any case. And the fact that she's been allowed to have the assistance animal going forward, the respondent still never gave her confirmation that she was able to have the assistance animal, that it wasn't going to be removed. And she occasionally would remove it from the premises because she was worried about what was going to happen and then bring it back. The dog feces, there are a lot of other dogs that live in that particular complex. And I couldn't get any evidence one way or another whose dog was responsible for the mess, but there were periods of time, at least one period of time, where complainant's dog was gone and there was still a mess because there were other dogs. So I don't think I have anything else to add, but I'm happy to answer any questions that you might have. This was a pretty narrow case.
Yep. Thank you, Kit. I was going to say commissioner questions, and Commissioner David is right there.
Kit, doesn't there have to be some adverse action? If they haven't removed the dog, they haven't evicted her for non-payment of rent, or
the only adverse action here is that she was told that the doctor's note didn't matter, and so essentially has been living this whole time thinking that they might be able to remove the assistance animal whenever, because they didn't accept the doctor's note as proof, basically.
A major thrust of the respondent's presentation is that she ignored requests to complete required forms. Did you ever inquire about that with her?
I did. She has, in fact, failed to complete the required forms and won't go to the office because she feels several other things at the complex have been discriminatory or unfair in some way.
Well, I mean, I'm not impressed by her own statements that she doesn't have a disability if she does. I mean, she might be embarrassed to say, she might, you know, I mean, there's all kinds of things go on there, but it does seem as though if she's being told that she needs paperwork to complete this, that she needs to do that.
I don't disagree that it would have been better if she had gone to complete the paperwork. Things certainly would be clearer. This case primarily rests on the fact that she submitted the note from a doctor saying that she needs the dog for a therapy dog, which is sort of old language for an assistance animal, to assist with her depression. And they basically told her that didn't matter.
Yeah, I mean, it certainly bothers me that they blow off the note. The note is clear. The note says she needs it. The note says it mitigates the effects of a disability, and they ignore that. So, boy, there's some conflicting things going on here.
There are, yeah. And I, you know, if I think complainant could probably speak to that more. I know she was here earlier, but I don't see her now.
Any other commissioner questions for the investigator? Seeing none. Thank you, Kit. So we've heard from the respondent, complainant did not appear. We've heard from the investigator. At this point, we would be looking for a motion or motions.
I'm going to move that there are reasonable grounds to believe that there was discrimination and the claim should be conciliated. That's the first one. And at the same time, 2 and 3, that there's no reasonable grounds to believe there was discrimination based on family status or receipt of public assistance or retaliation, and that those claims should be dismissed.
So just to clarify for note keeping, you're making a motion to adopt all 3 recommended findings.
Correct.
Okay, thank you. Is there a second? I believe Commissioner Doosan is, okay, you were mouthing it, but I needed to hear it. Thank you. So the motion is to adopt all 3 recommended findings. It's been seconded. Is there any discussion among commissioners?
Well, I do find it a very close case. It's very troubling that that there's nobody there to help her in a non-threatening way with the applications and the paperwork. But it really bothers me that they get a note that says it's mitigating the effects of a disability, and that they don't follow up on that, and that tips the scale. And I need to defer to my investigator's judgment on this one.
Any
I'm
other?
looking here, I have a comment. I'm looking here at the investigator's report, and even though it's far from clear that the complainant is an individual with a disability, the doctor's note did identify a condition which may be a disability. So had the motion split the 3 recommended findings separately, I may have voted with it, but I cannot get to the place with, even though it's close, with the first one being a reasonable grounds case. So I'll be voting against the motion.
Commissioner O'Brien.
Thank you. I also agree that it's very close, but I tend to agree with Commissioner Webworth on this. I just have a real problem, as I echo what has just been said.
Any other discussion among commissioners? Seeing none. The pending motion is to find reasonable grounds on the disability discrimination and no reasonable grounds on receipt of public assistance or familial status or retaliation against both Michael Albert, and Louis Albert. And if you vote yes, you are agreeing with all three of those proposed findings. Commissioner Whitworth.
No.
Hold on, I'm just making notes. Commissioner David,
Yes.
Commissioner Doosan. Nope, we can't hear you.
Yes, and you forgot Commissioner Ashby.
I did not forget him. He is recused from this case.
Oh, okay, thank you.
The one time I didn't forget someone. Commissioner O'Brien.
No.
So it is a tie, 2-2, and in that event, the motion fails. And the default finding is no reasonable grounds on all three. So all three findings are no reasonable grounds, unless somebody wants to make another motion on one of these. But barring that, all three findings are no reasonable grounds.
Then we can move on to our last case of the afternoon, Kimberly Norwood. I'm sorry.
You could hold on
H21.
just 1 second. Sorry, I'm sorry to interrupt you. Just for the parties and council who are here on the case we just finished, the commission will send parties and council a letter confirming the findings and outlining for Ms. Babin if she wants to pursue her claims, how to do that. Sorry, go ahead.
Thank you, everybody.
So our last case of this afternoon, H21-0272 AB, Kimberly Norwood v. Strictly Mobile Home Inc. and Mike Dennis. This is at least a partially reasonable grounds case. Oh, it is a reasonable grounds case. So we will hear from the respondent first. Is there anybody here for Strictly Mobile Home and Mike Dennis?
I don't see anybody who is here for the respondents.
Okay.
And so just for Ms. Norwood's explanation, typically speaking, when we have the party who has objected to proposed findings, when they don't appear, typically the commissioners don't hear from anyone, even if you're here, and they just vote to adopt the recommended decision. So you agree with the proposed finding, I presume. So
yes.
Typically the commissioners wouldn't hear from you. They would just go ahead and adopt the proposed finding.
Okay.
Sorry, Commissioner Whitworth. I probably interrupted you.
No, you didn't. So I think we need a motion.
Well, I'll move that we find that there are reasonable grounds that respondent discriminated against a complainant on the basis of disability because of denial of reasonable accommodations, and two, that there are reasonable grounds to believe that respondent discriminated for engaging in a protected activity, and that the conciliation should be attempted.
Second.
It's been moved and seconded to find reasonable grounds on both claims. Is there any discussion among commissioners?
Yeah, I'd like to thank Milo for his work.
You know,
Agreed. I'm not sure if this is the last time we see him.
I think we should make him present just for fun.
Yeah, seriously, I have some questions. I have a lot of questions about this case.
Yeah.
If the commissioners do actually want the investigator to present, please let me know. I'm presuming that that was not a serious request.
It was not.
Okay. So the motion has been moved and seconded. Is there any other discussion among commissioners about the proposed findings? Seeing none. Okay. The motion is to find reasonable grounds to believe that respondents discriminated against Ms. Norwood on the basis of disability, and that they retaliated against Ms. Norwood for engaging in MHRA protected activity. If you say yes, you are agreeing to reasonable grounds findings on both claims. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Okay, so both findings are reasonable grounds findings, and that completes our hearing agenda. Thank you, Mitch.
Can I ask a question?
Yes, you can.
Okay, what happens now?
So as I've said throughout the day, the commission will send you and the respondents a letter explaining the findings that happened today and describe the process that comes next.
Okay.
Okay, and I appreciate you being here. I'm sorry you were last and you waited here, so I really appreciate it.
All right. It's all right. Thank you so much.
Thank you. So at this point, we would be looking for a motion, if I could find my agenda, to go into executive session. Is there such a motion that cites the proper parts of the Freedom of Access Act statute?
I was going to make the motion, but now you've intimidated me by
It
telling me
it has to include the reference.
I don't have it in front of me.
I think I think it's in the materials. I believe that we upload for you all. There's a sample motion, I believe. I could be wrong about that.
No, I have it.
Okay.
So pursuant to 1 MRS section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Just like that. Jill seconds. The motion is to go into executive session. I will ask each commissioner, all commissioners, if you say yes, please, and you indicate that orally and with your raising your hand. It's visually obtainable. Those words made no sense, but if you say yes, then you are voting to go into executive session for the stated reasons. Commissioner Whitworth.
Yes.
Commissioner Ashby.
Yes.
Commissioner David.
Yes.
Commissioner Dusan.
Yes.
Commissioner O'Brien.
Yes.
Thank you. All right, so at this point, I'm going to try, I didn't set this up ahead of time because I wasn't paying attention. I am going to, oh, Mel started. I have to add some other people. Hold on. Hold on. Hold on. I'm going to add you and then move you. So Ms. Norwood, just so you know, we won't be seeing you. We're going into executive session. We'll come back out in a little bit.
Okay, so do I need to stay here?
No, not at all. Nope.
Okay. All right.
Thank you.
I'm gonna go then. Thank you.
Okay, thank you. All right, sorry, commissioners, I'm a little slow on the uptake right now. I'm trying to add you to the room. My brain is slow. Melody, can you help me? All right, I found it. Hold on, I found it. It's been a long day. I got you. I got you. I got you. Here we all go. All right, so we have 1, 2, 3, 4, 5 commissioners. So we don't have Melody, but that's all right. Is she the one who dropped off just now? Maybe. Okay. So we are looking for a motion to address the matters in which there are recommendations to litigate and to not litigate. And you can do them all together or separately. As in, litigate these and don't litigate these.
On the not to litigate item, you want us to make a motion which includes everything listed except Bragg versus Walmart.
Exactly.
Is that correct?
Exactly.
And I will move that we do not litigate the items in our memo. You want me to say the numbers for the cases? No. Okay.
No, I think we're okay. And is there a second for that motion to not litigate Pomeroy, Segroy, Lyons, and Smith?
Second.
Okay. All those commissioner, nope, I can't do it that way. The motion is to not litigate Pomeroy, Segroy, Lyons, and Smith. If you say yes, you are in agreement not to litigate those cases, which is very confusing. Commissioner Whitworth. I didn't hear you.
Sorry, yes,
Okay.
cold.
It's okay. Thank you. Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner Dusan,
Yes.
Commissioner O'Brien.
Yes.
Thank you. All right, so that's the not litigating. And then we need a motion on the ones to litigate.
Let's see here. I'll move that we litigate the two matters, case number, well.
There are technically
Rodriguez
3
versus-
cases.
Okay, I'll move that we litigate the 3 cases discussed in executive session. Is that an appropriate way to
Yes,
make
yep.
the motion?
Yep.
Second.
Okay, it's been moved and seconded to litigate the 3 cases discussed in executive session, which we will outline. All right, Jeff, I'm getting to it. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
got to see your hand. Thank you. Commissioner David,
Yes.
Commissioner Dusan.
Yes.
Yes, just getting creative. Commissioner O'Brien.
Yes.
Okay, thank you very much. I believe that is the last matter that we need from you, and I thank you for all a lovely, excellent meeting.
Thank you. Move to adjourn.
Thank you.
I hope you know I'm
Next
not
month.
making light of your work. I'm just trying to find a way to appreciate.
Yeah, no, I don't think you're making light of it. I think it's an irritating requirement. Exactly.
Melanie, are you still here?
Melody.
Melody is still here. Mel?
I need her. I want to talk to her on the phone if she got my email.
Sorry, yeah, it took me a minute to get back to the window. I was typing the minutes. Yes, I'll text you my phone number if you want to call me.
Yes.
Sure.
Email it to me.
Okay.
Thanks again for your rescue, Mel.
No
need
problem.
a
Sorry
motion to
about
adjourn.
that.
No.
We do not need a motion to adjourn.
Thank you. Goodbye. Have a great day,
Thanks.
everybody.
Bye. Thank you, everyone.